Item number 49, Lordship. With the consent of the other party, Lordship, I have taken the consent. I have to file the affidavit in opposition. Kindly give me 1 to 10 minutes.
On the prayer of Mr. P. Sharma, learned SCAFBC made with the consent of the other side. This matter stands adjourned for 2 weeks so as to enable him to file counter affidavit. List according.
May I
File
please,
your-
Your Lordship? May I please, Your Lordship? Your Lordship, item number 32 of daily list,
Yes.
with the consent of the other side, matter may be listed, matter may be adjourned for 2 weeks.
You are appearing for whom?
S. Kanunga, petitioner.
The learned counsel for the petitioner has prayed for adjournment in this case for 2 weeks. Since the prayer is made with the consent of the other side, so stands allowed. List accordingly.
May it please your Lordship. Lordship, item number 24, Lordship, with due consent of the other side, back to adjourn for 2 weeks, my lord. We'll file affidavit in this matter, my lord.
Ms. T. Bhatt, learned SC Corporation Department, Assam, has sought adjournment in this case for 2 weeks, so as to file counter affidavit. Since the prayer is not opposed, same stands allowed. List accordingly.
Oblige, your Lordship.
Please, Lordship.
Thank you.
Lordship, we have filed the affidavit in reply yesterday. That may be called up for recorded item number 31.
Item number?
31. Hold it. Right.
May please, your lordship. I beg to mention for listing for motion, my lord. My lord, it was last listed on 1/9/2023, my lord. Thereafter, the court has fixed after 1 week, but the matter has not been listed to
What is the matter about?
matter regarding the appointment of the petitioner, my lord, for the grade 4 post.
Next
On
week.
that,
Next
next to Monday, my lord.
Monday is a holiday, any other
Sure,
day.
Monday.
May I please, your lordship? Lordship, I beg to mention WBC 642 of 23. The matter is related for compenssionate appointment. It was last listed on 18/9/2023.
Next week.
Oblige.
May I please, Lordship? Lordship, my prayer is for listing a IL, Lordship.
Hmm.
Your Lordship has disposed the WBC. In the order of the WBC, there are some correction, Lordship. That may be rectified, Lordship.
When do you want it?
Next week, Lordship.
Yeah, please, Lordship. Lordship, I beg to mention one of contempt matter, Lordship, next week, Lordship.
Contempt matter, why you mention?
Lordship, last Lordship posted on 15/5/2023, Lordship, notice was issued, Lordship. Till then, Lordship,
No, but why it has no contempt matter, there is no urgency.
Lordship, respondent, Lordship, appeared, Lordship, but no, Lordship, matter is urgent, so,
You find out from the registry why it has not been listed.
Lordship.
But this matter pertains to compensate appointment. On the last occasion, instruction was called for. Perhaps
There is a recommendation by SLC.
yes.
Lordship, well, on last date, one of my colleague was here, Lordship. I have to take instruction from him whether any instruction has been received or not, Lordship.
No, but your colleague who was there is
Lord-
sitting by your side.
Ardhar was there, Lordship. I'm trying to contact him, Lordship. He's not available right now. Lordship, we'll take
Call
up.
him, then we'll take
Lordship,
up after
after
some
some
time.
time.
Yes.
May please, your lordship. Petition matter related to appointment of the Gaon Pradhan, my lord. My lord, in this case, my lord, the petitioner approached before the commissioner North Assam division, my lord. The commissioner directed to deputy commissioner to make an appointment within 13 days, my lord. But that order was not implemented, my lord.
Just now I have received an instruction, Lordship. Government decided to appoint him as a Gaon Pradhan.
So we'll record it and close it.
Yes.
Heard Mr.
F.A. Hassan.
F.A. Hassan, learned counsel for the great petitioner, peruse the order dated 17/11/2023 passed by this court. The petitioner is aggrieved due to inaction on the part of the concerned deputy district commissioner in his failure to issue the order of appointing the petitioner as the Gaon Pradhan. This matter was adjourned so as to enable the learned departmental counsel to obtain instruction. Today, when the matter is called up, Mr. S. Datta, learned standing counsel,
Revenue and disaster management.
Revenue and Disaster Management Department, submits on instructions received by him. A decision has been taken to issue the order of appointment in favor of the petitioner, and the same will be done during the course of Same
already
will be done
applied-
without further delay.
Lordship.
If that be so, nothing further survives for adjudication in this case. By recording the submission of Mr. Dutta, this writ petition stands disposed of.
My lord, according to us, it is covered by your lordship's order, my lord. The order is at page 42. In fact, a series of cases were disposed of. And there are other cases also, my lord, where other coordinate benches have also disposed of it, na? Kundu? Huh? Pune diya? Oh. And there are other cases where lordships has taken the same view, my lord. All by your lordships, yes.
Mayor, please, your lordship. Lordship, I kindly, page number 36 may be seen, my lord. This is the impugn order, my lord. In those earlier orders, my lord, the lordship has interfered because there is a specific stigma that we have before passing the order, my lord. But in this order, my lord, only thing is that the second last paragraph, my lord, may I read, my lord? Whereas the arrest and subsequent police custody of the employee has become embarrassing to the employer and esteemed organization. This is one of the clause of the agreement, my lord. And on the same issue, my lord, this Honorable High Court has passed this, my lord. By the
Yes. Oh, termination of contract.
Paragraph 7 is the clause, my lord. And clause,
Clause 9.
paragraph 10 is the finding, my lord.
Four.
See, to say that the conduct is embarrassing definitely raises a.
Exactly.
That is
Finger.
only point, my lord.
But Mr. Chaudhary, what
No,
can be done?
no, lordship will kindly come to page 24.
Page?
24.
No, send this order by the coordinate bench. Please see the paragraph 9 and 10.
Oh.
No, anyway,
Well,
learned judges.
With great respect, Manoj, where is the question of?
That's all right.
It's
That's
not
all
a
right.
contract determinable.
Only thing
in
is,
nature.
this court will have to deal with it.
Yes.
So we'll fix a short date after issuing
Yes,
notice
yes,
and let them.
yes.
My lord, my lord.
We'll have to deal with it.
Only point was, my lord, I was trying to draw your lordship's kind attention to clause 10 at page 24. Please come to that. The contract in this case. The contracts, 11, my lord. State shall reserve the right to terminate the contractual agreement at it. Sorry, my lord. Page 24, clause 11.
Yes.
It was order 9. Okay. The state shall reserve the right to terminate the contractual agreement at any time if it is found that the services rendered by the contractual staff is not satisfactory. This is where the catch is, my lord. Now, if it is not satisfactory, otherwise also it will be motive. But the moment you take note of some misconduct, then my lord, 311 to is
That's correct.
and my lord, with great respect, the judgment is a judgment per inquirium for the simple reason, my lord. The two most relevant point which ought to be considered was never considered. That was a judgment per inquirium, my lord.
That's right. But the learned judge has also referred to clause 11.
Yes.
Of the contract, which
Yes.
he also mentioned. But anyway, I don't wish to make any further comment. We'll just issue notice and fix it. Can you indicate a date?
Any date convenient to your lordships, my lord.
It
Only thing
appears
is
that
December,
this
my lord.
judgment does not consider the previous decisions of the court.
Yes.
That was submitted, my lord.
But that is not.
But
dealt
no,
with.
my lord, but the question is whether this is stigma or not. That is the point,
Huh?
my lord. Lordship has to determine,
No.
consider, my lord.
No, if you say that his conduct has become embarrassing for the department, it's not a stigma.
It is stigma, my lord, but it's a part of agreement also, my lord. That is not under challenge.
Oh, these are two different things,
My
Mr.
lord,
Datta.
Lordship will consider that. my lord.
Agreement is one thing and stigma is another
Yes,
thing.
yes, my
There
lordship,
can't be an agreement of stigma.
lordship.
You are saying that because he is arrested, it has caused embarrassment for the department
My
and his conduct.
lord.
It's not a stigma.
Lordship will consider that, my lord.
Will just that I propose to write out a judgment.
My lord.
That's why I'm
My lord,
postponing
my
it.
My
lord.
lord, in Radhesham Gupta's case, in para 34, dealing with all the cases of the Honorable Supreme Court previous judgment, Honorable Supreme Court has said when it will be motive and para 34 when it will be, foundation. It's clearly
That's right.
spelled out.
The conduct which was found to be embarrassing is the foundation of this order.
Exactly.
So anyways,
I understand, my lord. Lordship.
we'll
Any
fix
date
a-
convenient to your lordships, my lord, other than 5, 6, 7 December.
4th December? No.
Post.
4th December?
Court, I'll be not there, my lord. Could it be prior to that, my lord, 30th or I think 2nd, 3rd?
No, then we'll have it after 7th.
Okay,
8th December, 8th December. 4th you are not available.
4th I'll be going. my lord.
All right, all right. Then we'll have it on 8th December. Does it suit both the sides?
It could be 11, my
I
lord.
don't have any problem.
If it is not
11
11.
December. All right. Heard Mr. Ken Chaudhary and senior counsel is by Mr. Arvind Dekal, counsel for the writ petitioner. By filing this writ petition, the petitioner has assumed the order of termination from service dated 17/5. What is the date of the order?
1 second.
15/8/2023. 15/8/2023. On the ground that the order was stigmatic on the face of the record and therefore the petitioner's case is covered by earlier decisions of this court rendered in the case of Surojit Burman versus State of Assam and other, page 42 Pabuk, WPC number 1785 of 2022 and several other similar decisions. Mr. S. Datta, learned SC PNRD on the other hand has produced a copy of the order passed by the learned single judge in a similar matter in the case of Jan Saikia versus State of Assam and 5 others. Third bracket, WPC number 4632 of 2023 to contend that a similar writ petition has been dismissed by the learned single judge and therefore this matter requires to be considered on its own merit. Although Mr. Ken Chaudhary, learned senior counsel, has argued that the decision in the case of Jan Saikia Supra is a judgment peremptory as the same does not take note of the previously decided cases by this court. I am of the view that the matter would call for detailed deliberation and further consideration. As such, issue notice of motion returnable on 11 December 2023. Since Mr. Datta has appeared in
All the respondents.
no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel so as to enable them to file affidavit. Considering the facts and circumstances of the case and the fact that the petitioner's services have been terminated on the ground stated in the order, this court is of the opinion that the writ petition calls for expeditious disposal. As such, it is made clear that the matter will be taken up for disposal at the stage of admission hearing. Parties to come prepared accordingly.
My lord, I'm very sorry. Let it be 14th, my lord. 14th, same week.
14th.
14th. Deeply obliged.
Obliged.
Lordship, here in this case, Lordship, on the last date, Lordship, I was asked to obtain the report, Lordship. I have the report, Lordship. Let notice be issued. I'll file an affidavit to this.
My lord, advertisement will issue, my lord. Till then, my lord.
No, Lordship, his
fresh
post is
advertisement
not
has been-
mentioned in there.
Let him place his case. Let him place
Yes,
his
yes,
case.
My lord, input order is page 69, my lord.
Yes.
May I read from second paragraph, my lord?
Yes.
Whereas pending the medical test for PWBD, the appointment order was issued inadvertently in respect of the said candidate for appointment to the post of junior sen, Lagos so and so pursuant to such appointment order, the said candidate has joined the service on 1st June 2023. Then, my lord, last paragraph. Therefore, in view of the medical report about the ineligibility of the candidate and terms and conditions of the appointment of Gaurav, son of so and so is cancelled, terminated, my lord.
So let him file affidavit, but you can't fill up that vacancy till the returnable date.
Lordship, his post has not been mentioned, Lordship, in the advertisement.
Sorry?
His post has not been mentioned in the advertisement.
All right, whatever one post, you will have to keep it vacant. Because if he succeeds, then how will you accommodate him? Or you know that he will not succeed.
And Lordship, it is the final.
Do you have any special knowledge that the petitioner will lose the writ petition?
Lordship, I am appearing for the department, Lordship, health department, but the finance department is the appointing authority, Lordship.
All right, we'll issue a direction. We don't know who is what. Take down heard Mr. S.K. Roy, Learned Counsel appearing for the writ petitioner, assailing the order of termination from service dated 7/6/2023. The petitioner has approached this court inter alia contending that the impugned order has been issued in a most arbitrary and illegal manner. Full stop. It appears that the petitioner was earlier appointed in the post of junior assistant dash class 3 as a candidate belonging to the PWD. Is it PWD?
Person with
Persons with-
benchmark disability. Persons with benchmark disability.
Persons with benchmark disabilities, bracket or above, capital P, small w, B or D, to do the capital, bracket close. However, subsequently, the department had found that the appointment order was issued on erroneous assessment of the disability of the petitioner, and that is why the same was cancelled. Full stop. Mr. D. Upamanyu, Learned Standing Council, Health and Family Welfare Department, Assam. You are Mr. Upamanyu, is
Yes.
it? I can see only half of it. Yes.
Yes, Lordship, for 7, 8, and 9, respondent 7, 8.
Appearing for the respondent numbers 7, 8, and 9, submits that he
Union.
has received instructions and therefore be granted 3 weeks' time to file affidavit. Similar is the stand of Mr. P. Nayak, Learned SC Finance Department.
Finance,
Assam,
Lordship. I'm appearing for 4 and 5, Lordship.
appearing for the respondent numbers 4 and 5. In view of the above, we should notice a motion returnable on 20th of December,
My
18th of December,
28.
18th of December,
My
18th of December. Since who is appearing for whom? Since Ms. R. Devi, Learned CGC has appeared and accepted notice for respondent number 1, Mr. J.K. Goswami, Learned Additional Senior Government Advocate, Assam, for respondent number 2, Ms. J. Gogoi, Learned Standing Council, Water, Social Justice and Empowerment Department, for respondent numbers 3 and 8, Mr. Nayak for respondent numbers 4 and 5.
4 and 5, Lordship.
4 and 5.
For 7 and 9.
Who is for 6?
State level recruitment.
B. Sodri is appearing.
Huh?
B. Sodri, Lordship. appears. He is present. I'll inform you.
B. Chaudhary means SC APDCL.
Yeah, no, Lordship. Bikram Sodri.
Become.
Mr. V. Chaudhary for respondent number 6 and Mr. D. Upamanyu for respondent numbers
7 and 9.
8 and 9. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the Learned Departmental Council within 3 days from today, so as to enable them to obtain instruction and file affidavit. Hard on the prayer of interim relief, it is submitted at the bar that fresh advertisement has already been issued for filling up number of similar posts. In view of the above, and so as to protect the interest of the petitioner till the returnable date, it is made clear that one post of junior assistant grade 3 for the category of PWBD shall be kept vacant till the next date fixed.
obliged.
List the case on 18/12/2023 as a fixed item.
Highly obliged.
The Learned Departmental Council to also produce the relevant records on the next date phase. We'll see if your consideration turns out to be correct, we'll dismiss the writ petition. Otherwise, orders will follow. Show us what was the error, who made the error, how the error happened. You can't, if you have made a reassessment and come to a separate finding, then you have to show us what is the basis of that.
Highly obliged.
Item 5.
May I please your lordship? The
Yes.
matter pertains to non-payment of family pension.
But it is family pension.
Yes, madam.
You are appearing in which item?
Item number 5,
Case number?
6685 of 23.
Oh,
Wrong number from the case. I don't know. Select highlighting.
yes.
Lordship may issue notice to the state.
No, but what is your preliminary submission?
Lordship,
Your
I have to
name,
take it.
please? Your name, please?
K. Burman.
But Ms. K. Burman, counsel appearing for the writ petitioner, peruse the averments made in the petition. The petitioner is aggrieved due to non-payment of family pension on account of her deceased husband. Mr. N. Upadhyay and Standing Council Irrigation Department, Assam, prays for 3 weeks' time to obtain instruction in the matter. Issue notice of motion returnable in 3 weeks. Since Mr. Upadhyay is appearing
1, 3 and 5, Lord.
notice on behalf of respondent numbers 1, 3 and 5. Who's for the pension? Mr. J.K. Goswami, learned additional senior government advocate Assam for respondent number 2. Mr. A. Hassan, learned SC AG Assam for respondent number 4. And Mr. P. Nayak, learned SC Finance for respondent number 6. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers be furnished to the learned department council so as to enable them to obtain instruction and file affidavit facilitating expeditious disposal of the writ petition.
Finding matter item 1.
Lordship, in this matter, instruction is awaited. Lordship, instruction are coming from Silchar, Lordship. Lordship, in his, after his selection, Lordship, by the SLC, Lordship, he was sent for appointment, but at the time of verification, he failed to furnish his graduation certificate. Subsequently, it was submitted, Lordship. Accordingly, file was sent to the government, Lordship. Now, presently, it's under government, Lordship. So we are waiting for instruction, Lordship.
So now he has furnished the certificate.
As per pleadings, Lordship, he has furnished, Lordship.
To the later date 16/5/2023, we have submitted the required qualification certificates, which we could not submit at that time of scrutiny. My lord.
All right, you're right. I heard Mr. S. Mr. Learned Counsel for the petitioner also peruse the averments made in the writ petition. This matter, the petitioner is aggrieved due to non-issuance of order of appointment despite the recommendation made by the SLC favoring his appointment on compassionate ground. Mr. Nayak, learned Standing Council, your
PWD, Lordship.
PWD Assam submits that the reason for non-issuance of appointment order is on account of failure on the part of the petitioner to submit requisite certificate in support of his educational qualification. However, subsequently, the certificate has been submitted by the petitioner and therefore 10 days further time be granted to obtain updated instructions. Taking note of the request made by Mr. Nayak, this matter is directed to be listed again on 24th November?
Lordship.
Or should it be
24 November? 24?
No, 24th is, yeah. Let it be listed on 1st of December?
Lordship.
1st December,
7 days.
1/12/2000 for motion.
Lordship, after 7th, Lordship.
Huh?
10 days I will get, Lordship.
After 7th?
Lordship.
No, we are on 22nd today. So first will be 10 days.
Lordship.
10 days should be enough.
Item 6.
May I please your lordship? Petitioner retired as superintendent from the respondent APDCL on in September 2021, lordship. And on the last month of his retirement, lordship, his pay has been fixed retrospectively. by taking away 3 promotional increments, Lordship.
So
Three
here
pro-
notice has to be issued.
Yeah, yeah.
Heard Mr. Vijay Sharma and counsel appearing for the writ petitioner. The petitioner is a retired employee of the APDCL. Full stop. He has approached this court alleging anomalous pay fixation after pay fixation, as a result of which there has been discrepancy in disbursement of pensionary benefit to the petitioner. Mr. R. Sharma, learned
SP Sharma.
SP Sharma, learned Standing Counsel APDCL, has appeared for the respondents and has prayed for 4 weeks' time to obtain instruction to file affidavit. In view of the above, NOM 4 weeks, since Mr. Sharma has accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition, requisite numbers, be furnished to the learned Standing Counsel so as to enable him to obtain instruction, facilitating expeditious disposal of the writ petition. Add one more line. Pendency of this writ petition shall not be a bar for the authorities to redress the grievance of the petitioner if so advised.
May it please the Lordship. Lord, in this case, the petitioners have been deprived of the benefit of old pension scheme merely because, my lord, for the fault of the authorities, they have been appointed after 1/2/2005. Now, the Appeals Court is make the position very clear that the date of participation in the examination is the cutoff date for giving the benefit of old pension scheme. So at this stage, your lordship may issue notice to the other side. And
Where is the decision of the Apex Court?
yes, yes, that your lordship will find at page, my lord, page, I'll take your lordship at page 65. Para 5, my lord.
Yes.
Paragraph 5, your lordship will see. It has been consistently held by this court in a series of orders that those who had participated in the examination of 2003 would be covered by the OPS, notwithstanding that they had been offered letters of appointment only after January 2004. And this order was challenged in the Appeals Court. Appeals Court also dismissed their petition. The Appeals Court order, your lordship will find at page 70.
All right, who is appearing? What is your stand? Can it be disposed of?
Lordship, some time may be given, my lord, for instruction, my lord. Notice may go, my lord.
All right, heard Mr. S. Gupta, learned Senior Counsel, estate by Mr.
DJ Medin.
DJ Medin, learned Counsel appearing for the writ petitioners. Also heard Mr. S. Gupta, learned SD PNRD Assam appearing for the departmental authorities. First of the writ petitioners are aggrieved due to the decision of the respondents to deny them the benefit of old pension scheme by ignoring the date on which they had appeared in the selection test. In selection test, is it? Or
Yes,
written
yes.
test? In the selection test. Mr. Datta, learned Senior Counsel for the petitioner, submits that this matter is covered. The issue is covered under the decision of the Delhi High Court as well as the Supreme Court of India, rendered in the case of Navin Kumar Jha versus Union of India, and therefore the writ petition deserves to be allowed. Mr. Datta, next, Mr. Datta, learned SC PNRD Department Assam, on the other hand, has prayed for some time to obtain instruction in the matter. So there is no urgency here. We'll issue 6 weeks.
It's
Issue
all right,
notice
my lord. Only
before-
thing, my lord, at page 63, I think this order may be statement.
What is the order?
At page 63, your lordship will find, with reference to the subject and reference cited above, I am directed to inform you that as per the Finance Budget Department SOAM number so and so, the new defined contribution pension scheme has been introduced to all the new entrants joining in service in the state government on regular basis against vacant sanction post on or after 1/2/2005.
But why should we stay?
Yes. My lord, this is expressly illegal in view of the Appeals Court
All right,
decision.
they only asked for GPF account statement. That's all.
So that we have given, but they are saying we are not entitled to because we
That
are-
is the subject matter of decision in the writ petition.
Then, my lord, returnal maybe 4 weeks.
No, I don't understand, Mr. Datta. What is that is pinching you in this They say you are not entitled to, that's fine.
Yes, yes.
We'll say whether you are entitled to
All
or
right.
not. Then what is there in it? There's no heard on the prayer of interim relief having regard to the, oh, it's a issue notice so and so. Mr. Datta has appeared and accepted notice on behalf of respondent numbers
1, 2, 3, 6, 8, and 9.
1, 2, 3, 6, 8, and 9. Mr. CKS Barua, learned Government Advocate Assam for respondent numbers. Respondent number 7. Who's for 4?
Director.
4, sorry, I am for 4 on.
Total 4.
The commissioner role is
1 to 4 and very codable, 8 codable. Mr. P. Naik, Learned SC Finance for respondent number 5. Mr. CKS Barua, Learned GA Assam for respondent number 7. Up to 8 and 9, we take over, Mr. S. Datta. In view of the above, service of notice upon respondent number 1 to 9 is deemed to be complete in this case. Why you want respondent number 10? What has he
Then, my
got?
lord, that was the post, my lord, we are from Dhemaji district.
Hmm.
We ought to be accommodated there. He is from Darang district, my lord. He was given the appointment earlier than us. That was post allotted to us.
Extra copy of the writ petition, requisite in numbers be furnished to the Learned Department Council. Petitioners to take steps for service of notice upon respondent number 10 by registered post with AD. Heard on the prayer of interim relief. Mr. Datta has prayed for suspension of operation of the letter dated 8/6/2022, bracket annexure Roman 11. Having regard to the facts and circumstances of the case, it is hereby clarified that the validity, it is hereby clarified that the instructions issued in the said letter shall be subject to the final order passed.
Much.
Hello, pleasure.
Gav Pradhan.
Lordship.
Yes.
Lordship, the petitioner he had earlier approached the honorable court. The direction is at page 42 also.
Notification.
Paragraph 8, Lordship.
Lordship, here in this case, a notification was published
Hmm.
on 16/11/2013, whereas the Department of Revenue and Disaster Management is empowered to try the appeal, Lordship, which is pending before the Divisional Commissioner, Lordship. After abolition of the post of the Divisional Commissioner, Lordship, now all the files were sent to the Department of GAD, Lordship. And now after this notification, Lordship, it is all the files are segregated and sent to the Department of Revenue and Disaster Management for disposal. All the appeals will dispose of by the Revenue Department, Lordship.
Your appeal is pending.
Lordship.
So how long will it take? Within 60 days dispose of this?
Lordship, I have already annexed a similar order at page, Lordship. Page 44, Lordship.
Take down. Heard Mr. S.K. Das, Learned Counsel for the writ petitioner, also heard Mr. A.K. Goswami, Learned Additional Senior Government Advocate Assam, appearing for the state. Mr. A. Puppan,
For number 2.
Learned Standing Counsel, GAD Assam, is present on behalf of the respondent number 2, whereas Mr. S. Datta, Learned SC Revenue Assam, has appeared for respondent number 1. The writ petitioner is aggrieved due to his non-selection for the post of Gav Pradhan of charge number 20, Muja Govardhana under Baranagar Revenue Circle, Sorbhug in the district of Borpeta. The petitioner had submitted his candidature for the said post in response to the advertisement notice dated 3/9/2022. Full stop. However, on conclusion of the process, the respondent number 5 was selected for appointment as Gav Pradhan in the aforesaid village. Full stop. Assailing the selection of respondent number 5 on various grounds. As selection of respondent number 5 as the Gao Pradhan on the twin grounds that he had failed to submit permanent residence certificate and Bakijay clearance certificate as required under clause 3 bracket Roman 5 of the notification dated 10/4/2018, as well as per clauses 10 bracket numerical 8 and numerical 9 of the advertisement notice. Full stop. It has been brought to the notice of this court that the petitioner has already filed an appeal under
Division.
appeal numbered and registered as RR 18/2023 before the Lower Assam Divisional Commissioner. But due to the abolition of the post of Divisional Commissioner, no progress has been made in the appeal. Hence this weak petition. First up, Mr. Goswami as well as Mr. Fukan, learned counsel appearing for the respective departments, submits that after the abolition of the post of Divisional Commissioner, all appeals are now been, records of all the appeals are now being transmitted for being heard and disposed of by the
Revenue and disaster management.
No,
But it-
GAD.
yes.
But GAD,
GAD, who will decide? Who?
my lord, the principal secretary.
By the principal secretary, GAD.
Now revenue. Now revenue. will
Now
decide.
revenue department. Revenue and disaster management will decide.
Principal
Lordship.
Secretary, Revenue and
Revenue and
Disaster
Disaster.
Management Department, Assam. And therefore, the appeal preferred by the petitioner would also be disposed of in a time-bound manner. Full stop. If that be so, and taking note of submissions made by learned counsel for the parties, as well as the similar orders passed by this court in earlier proceedings, this writ petition stands disposed of by providing that the records in connection with the appeal filed by the petitioner be transmitted from the office of the Lower Assam Divisional Commissioner to the office of the Principal Secretary, Revenue and Disaster Management Department within 3 weeks from today, if not already done. Thereafter, the appeal be considered and disposed of on merit as expeditiously as possible, but not later than 60 days from the date of receipt of the records. With the above observation, the writ petition stands disposed of.
Item 9.
May it please your lordship. Lordship, this is a matter of lordship, compulsory retirement from his service, lordship. The speaking order dated 5/11/2023. The fact is that lordship, the petitioner, the railway inspector, he had taken his charge on 31/5/2022 as per procedure of railway procedure, lordship. Thereafter, lordship, on 12/11/2022, a direction was given to him to clean the area, post area. Then clean up service were taken up, and on 13/11/2020.
Where is the order dated 5/10?
Yes, lordship, annexer W, page 151. And relevant portion is lordship 154, lordship. The bottom, lordship, bottom area, compulsory retirement. May I read the paragraph, lordship? The case file has been meticulously studied by the undersigned and found that contentions put forth by the party church in his defense reply do not hold any merit. The disciplinary authority, DSS/LMG, has forwarded the case to the undersigned with the opinion that the party church warrants deterrent punishment as the act committed by him is grave in nature and unbecoming of a member of force. As per Schedule 3 of RPS Rules 1987, the punishment warranted in this case is beyond the competence of the disciplinary authority, DSC/LMG. After taking into account all aspects relevant to the case, it is concluded that he is guilty of the charges leveled against him. Keeping in view the gravity of the charges for which he has been held guilty.
All right, now this order is appealable.
Yes, Lordship. Appeal preferred, Lordship, that what happened, Lordship, during pendency of the appeal, the petitioner is not allowed to continue his duty, Lordship. He is
No, that will not be allowed unless the order is set aside.
Appeal has been filed only on 1st of November, Lordship.
Yes, Lordship.
Still,
So let
1
the
month is not,
disposed of within 60 days.
Lordship.
Lordship.
Take down, heard Miss B. Talukdar, learned counsel appearing for the writ petitioner. I have also heard Mr. B. Chakravarti, learned CGC appearing for the respondents. First up, the writ petitioner herein was an employee of the
RPF.
Railway Police,
Railway Protection Force.
Railway Protection Force, bracket RPF, and was posted at the
New Guwahati RPF post.
New Guwahati RPF post when a disciplinary proceeding was initiated against him. The DP culminated in the order dated 5/10/2023. In the speaking order dated 5/10/2023, issued by the disciplinary authority cum PRP capital small r dot CSC public RPF, whereby the penalty of compulsory retirement was imposed upon the petitioner on the ground of the misconduct or found to have been committed by him. First up, agreed by the order, speaking order dated 5/10/2023, the petitioner has preferred a statutory appeal before the Director General RPF on 1/11/2023. However, contending that no interim relief has been granted to the petitioner by restoring his service during the pendency of this appeal, the instant writ petition has been filed. Ms. Talukdar submits that since there is no certainty as regards the length of time that will be taken for disposing of the appeal, a prayer for the prayer for interim relief made by the petitioner ought to be considered. Mr. B. Chakravarti, learned CGC, on the other hand, submits that the appeal has been preferred only on 1st of November 2023, and the same will be disposed of expeditiously. If the petitioner desires, it is open for him to seek interim relief even before the appellate authority. As such, the writ petition be not entertained at this stage. As such, he submits that the writ petition is premature and is liable to be dismissed on such ground. First up, it is the admitted position of fact that an appeal lies against the impugned speaking order dated 5/10/2023, and the petitioner has already preferred an appeal which is pending disposal.
Under Rule 211.
Already preferred an appeal under Rule 211
of the RPF rules, 1987.
Of the RPF rules 1987, and the writ petitioner has already preferred an appeal before the authorities. If that be so, the appeal is required to be heard and disposed of expeditiously before the petitioner can acquire any right to approach this court by filing the writ petition. First up, in view of the above and having regard to the peculiar facts and circumstances of the case, this writ petition is disposed of by providing that the appeal preferred by the petitioner be disposed of as expeditiously as possible, preferably within a period of 60 days from the date of receipt of a certified copy of this order. First up, the petitioner would also be at liberty to seek an interim relief of reinstatement in service before the appellate authority, if so advised, which prayer be considered on its own merit. If the petitioner continues to remain aggrieved in the matter, it will be open for him to approach this court by filing, once again, by filing appropriate proceeding. With the above observation, the writ petition stands disposed of.
Obliged, Lordship.
Item 10.
The Mayor, please, your lordship.
Yes.
Petitioner originally appointed as Home Guard. Thereafter appointed as SPO, that is in case number 18, your lordship, SPO certificate is.
Prepare a fresh merit list.
Yes, sir. Again, lordship discharge certificate is on page number 19.
So why a fresh merit list should be prepared? Your client has appeared in the test.
Yes, lordship.
He has become unsuccessful. Then why a fresh merit list should be prepared?
Lordship, my SPO mark
Everybody
is not
appears in a
awarded,
test and fails and comes to the
lordship. My
court and
SPO
says,
mark is not awarded, lordship.
what?
My lordship SPO mark is not.
SPO
awarded.
mark.
Lordship, in page number 51, in the advertisement is clearly said that that experience as SPO will earn 2 marks for each qualifying 1 year, and it will not exceed 10 marks. And in my page number 60, lordship.
All right, you obtain written instructions. We'll fix it on. You are Mr.
P. Chakraborty.
Mr. P. Chakraborty and counsel for the petitioner. Where is
Lordship,
the amendment?
Lordship, similar matter is also pending, lordship. That is, that matter can be taken together.
First, let us see what is
Lordship.
his instruction.
Lordship.
We'll post it for motion. Peruse the amendments made in the petition. The petitioner herein had participated in the recruitment process for appointment of state special police officers conducted by the state level police recruitment board Assam, but was unsuccessful in the said process. According to the petitioner, the marks on account of his previous experience as SPO was not added to the total marks obtained by the petitioner, as a result of which he had remained unsuccessful. Full stop. The petitioner therefore has prayed for an order directing the respondents to prepare a fresh merit list by adding his SPO experience mark to the grand total. Mr. J.K. Goswami prays for and is granted time till 1/12/2023 to obtain written instruction responding to the obtain preliminary written instruction responding to the allegation made by the petitioner. One extra copy of the writ petition be furnished to Mr. Goswami during the course of the day. List the matter again on 1/12/2023 for motion.
Item 11.
Will oblige, your lordship.
Also, this is also similar with item number 8.
Item number 8, lordship.
So it is charge number 15.
Charge number 15. Moja Singh.
Moja Senga under Senga Revenue Circle. And then what is the ground of challenge?
Lordship, the respondent number 5, he could not submit the land documents, lordship, proper land documents.
On the ground that the respondent number 5 could not submit proper land documents. बाकी के लिए क्या होगा?
And petitioner is the son of the Gaon Pradhan, lordship, and he also worked as in charge Gaon Pradhan, lordship.
Moreover, the petitioner is the son of erstwhile Gaon Pradhan and he has also worked as in charge Gaon Pradhan, and therefore proper weightage ought to have been given to the candidature of the petitioner on such count. A proper weightage of his experience ought to have been given to the candidature of the petitioner on such count. The appeal number of RR 41/2023. Baki had to dispose of. Sure.
Item 12.
What about us? May please, Lordship.
Preferential appointment under Assam Public
In
Service
pursuance
Rules.
of advertisement, my lord, petitioner have absolutely requisite qualification to claim the appointment, my lord. Without any assigning any reason, my lord. Only opinion has been passed that candidate is not qualified. And against that impugn order.
So we'll have to issue notice here.
Declare.
Or Mr. B. Islam, Nair counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved by his non-selection for appointment to the class 4 post conducted by State Level Recruitment Commission for the Assam Administrative Staff College, Johar Nagar, Kanapara, on the ground that the process is vitiated by whimsical decision of the authorities. Mr. C.K.S. Borua learned Government Advocate Assam prays for some time to obtain instruction in the matter, issue notice returnable in 6 weeks since. Who is appearing for whom?
This matter, actually, I'm appearing for the respondent 1 and 4, but they haven't made us party. I mean, since our name is not reflected in the cause list, now they served me copy.
All right, Secretariat Administration is there.
SAD.
Mr. A. Fukan, learned SAD stroke GAD has accepted notice for respondent numbers 1 and 4. Who is for 2 and who is for 2?
2, 5 and 6.
Mr. C.K.S. Borua, learned GA Assam for respondent numbers 2, 5
2, 5, 6.
and 6. And Mr. S. Datta, learned SC Revenue Department Assam for respondent numbers 3 and 7. Service of notice is deemed incomplete in this case. Extra copy of the writ petition is furnished to the learned department council so as to enable them to obtain instruction. This is the class 4 post in the class 3 and 4. Conducted by the state level selection board. And these posts are for administrative staff college.
Advertisement.
Administrative staff college.
22,
3 and 4.
21, 2002, 21.
All right, let this matter be listed by reflecting the name of learned departmental council in the cause list.
Item 13.
May I please, Your Lordship? Lordship, this application is claiming two entitlements, right, Lordship. One is areas and the other is unpaid salaries, Lordship. Lordship, the case is that, Lordship, we are initially appointed as casual employees, Lordship, on fixed pay basis, Lordship, and thereafter, Lordship, we are brought under the minimum pay scale, Lordship. And minimum pay scale was allowed with effect from
Please issue notice here.
Lordship.
Mr. S. Talukdar, learned counsel for the writ petitioners, peruse the amendments made in the writ petition. The petitioners are aggrieved by non-payment of their due salary and allowances, as well as the arrear salary, which according to the petitioners ought to have been paid to them by the respondents. So Ms. J.C. Gogoi, learned standing counsel, Water Resources
No,
Department.
Lordship, it's Dimahasa, not Kasai, it's autonomous council.
Achha, then who? Ms. J.C. Gogoi, learned standing counsel, Dimahasa Autonomous Council, has paid for some time to obtain instruction. Similar is the prayer of Mr. P. Nayak, learned SC Finance Department, Assam, as well as Mr. J.K. Goswami, learned additional senior government advocate, Assam, and Mr. D. Upamanu, learned standing counsel, Health and Family Welfare Department. In view of the above, NOM 6 weeks, since Ms. Gogoi has accepted notice for respondent number 1,
4 to 9, Lordship. 4 to 9.
1 and 4.
I am appearing.
This is Mr. J.K. Goswami, and additional senior government advocate, Assam, has accepted notice for respondent number 1. Mr. P.
2 and
Nayak,
10 I am appearing. 2 and 10.
Mr. P. Nayak, learned SC Finance for respondent numbers 2 and
10.
Mr. D. Upamanu, learned SC Health for respondent number Three, respondent number three. And Miss Jessie Gogoi, Learned Standing Council, Dima Hassau. Autonomous Council for respondent numbers 5 to
4 to 9.
4 to 9. Service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the Learned Departmental Council so as to enable them to obtain instruction and file affidavit.
Such pendency shall not be barred. Pendency shall.
Forget it. Two contempts you will have to file. They are not going to pay you salary.
Item 14.
May I please, Your Worship? Let person with a departmental proceeding, petitioner imposed with a fine, let an amount equivalent to 3 days pay. And on being agreed, earlier also one writ petition was filed without exhausting revision remedy. In terms of the order passed in earlier WBC, we appeared with one revision petitioner preferred before the authority concerned, and impugn punishment is appeal. That is the case. We are challenging it by way of this writ petition. Impugn punishment lordship page 70 to operative page. Page 70.
What is the date of the order of penalty?
3/11/2021.
So we'll issue notice.
Lordship.
This is heard Mr. K. Raman, counsel for the writ petitioner. Also heard Mr. K. Gogoi, learned CGC, appearing for the respondents. By filing this writ petition, the petitioner has assailed the order of penalty dated 3/11/2021, as well as the subsequent orders passed by the revisional as well as the appellate authority, affirming the penalty imposed upon the petitioner by the disciplinary authority. Mr. K. Gogoi, learned CGC, prays for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Gogoi has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition will be furnished to the Learned Department Council.
Item 15.
How many cases you have?
15, 16, 17.
Same order.
The department advertises I have an error, mistake done. In synopsis, advertisement date should be 7/12/2021. And in the list of dates, I may be allowed to 7/12/2021.
So all the cases, your grievance is that the petitioners, despite being selected candidates of the PWD category, no order of appointments have been issued to them till today.
No, here is not issued, Here is not issued in this case.
Not issued, Lordship.
Appointment order not issued. Other candidates have been issued, my lord. Other reserved category.
All right. You obtain instruction and preliminary.
Notice.
We'll post all the matters on 4th of December for
Lordship.
motion.
The first item was on 18th, Lordship. Item 4.
No, we'll pass same order in item 18,
15, 16, 17, Lordship.
15, 16, 17.
On 4th, Lordship.
On 4th December for motion. Let him obtain instruction.
My lord, here, in item 16, my lord, there is a fresh advertisement, my lord.
Suleiman.
No, the reason for not issuing the appointment order, let him tell us.
Yes, Lord.
Heard Mr. Esker, same order in 15, 16, 17, common order. In all these writ petitions, the petitioners are aggrieved due to non-issuance of order of appointment in their favor, despite having selected as candidates eligible for appointment as under the persons with disability, bracket P, small w and capital D, bracket close, category candidates. Considering the nature of grievance expressed in this writ petition, this court is of the opinion that the Learned Departmental Council should be asked to obtain preliminary instruction responding to the allegations made in the writ petition. As such, let these writ petitions be listed again for motion on 4th of December 2023. On the next date fixed, Mr. Upamanu to obtain written instruction in respect of each of the petitioner and appraise this court the reason for not issuing the order of appointment in their favor. One extra copy each of the writ petition be furnished to the Learned Department Council within 2 days from today. You give him extra copy.
Only one copy.
Yes. You want to give 2 or 3? You want to
one
give
will-
more, you give, how many you want?
One, Lordship.
1 each. What will you do? There is no space to keep.
Highly obliged.
Item 18.
Yes.
May I do the Lordship? No, this is a compensation appointment matter, Lordship. Lordship, there is an order of this honorable court in the year 2014 to place the matter before the SLC. His name was recommended by the DLC, but later no action was taken, and therefore this court directed the department to place the matter before the SLC and inform the petitioner.
So, who died?
The father of the petitioner.
When?
2000, Lordship. Lordship, there is some development, Lordship, in this matter. Lordship, may kindly turn to page 36. 46, Lordship. 1 year back, the Borbetta division of the department collected my requirement by calling me and sent this to.
All right, heard Mr. R. Sharma, Learned Counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved by non-consideration of his case for appointment on compassionate ground. Mr. J.K. Goswami, Learned Additional Senior Government Advocate, has questioned the maintainability of the writ petition on the ground of delay and laches. He has, however, sought 8 weeks' time to obtain further instruction. In view of the above, issue notice of motion returnable in 8 weeks. Since Mr. Goswami has appeared and accepted notice for
1 to 6.
Respond numbers 1 to 6.
1 to 6. 7, Lordship, P. Nayak, Lordship, Finance Report.
And Mr. P. Nayak, Learned SC Finance for respond number 7. No formal notice is required to be sent in this case. Extra copy of the writ petition requisite in numbers be furnished to the Learned Department Council. Let this matter be listed again by reflecting the name of Learned Standing Counsel for the respondents and the cause list. Yes.
For addition, item 19.
Wait, please, your Lordship. Well, matter partners will let appointment of competition ground manner. Last pocket and well, instruction was called for me.
So your case has been considered and rejected earlier.
My lord, rejected my lord on the ground that my lord, the petitioner's father, my lord, had less than 3 years of service remaining on that ground, my lord.
But that has been now set aside.
My lord, yes, that was set aside, my lord, that was interfered, my lord. That part was interfered, my lord.
That order of the single judge has been interfered with.
Yes, my lord. Now, my lord, the petitioner has come into zone of consideration, my lord.
No, where is the division bench judgment?
Lordship. Division bench. Lordship, that was appeal to file was no. Appeal to interfere with me. Dependence. Interfere force me with that. না এই যেটা আমার appeal to the মানে এই যে 3 years যেটা balance service to চলে আছে interfere করে না
And there were new cases for the instance of the senior government some new cases have been filed also. And earlier cases may admitted, but in the case of still also there's no such information. Otherwise, all these matters are pending for a revision.
State of file question.
Appeal number.
Appeal number 2 is
Then we'll adjourn it. Let the division bench
Yes.
matter be decided. Now no direction can be issued.
Lordship.
Part Mr. S. Hawk, Learned Counsel for the petitioner. Peruse the amendments made in the writ petition. Mr. Hawk submits that the SLC had rejected the application for compassionate appointment made by the petitioner on the ground that his father did not have more than 3 years of service left at the time of his demise. Father, is it? Father?
Father.
First up. Mr. J.K. Goswami, Learned Additional Senior Government Advocate, Assam submits that the appeal preferred by the state against the judgment of the learned single judge, setting aside, interfering with the government notification is still
2000.
pending, and therefore he be granted 3 weeks time to obtain instruction as to the stage in which the aforesaid appeal is presently. Aforesaid appeal presently is. First up. In view of the above, this matter stands adjourned for 3 weeks so as to enable the learned government advocate Assam to obtain updated instruction. Unless that is settled, what will you do here?
Yes,
It is all
Item 20.
That's part. Oh.
That's
In this case, affidavit,
No, actually, so far affidavit is concerned that this has become a history. Because they have their record. The record may be placed before your lordship, and your lordship may examine these things. Since the matter of 2020, on several occasions they prayed for affidavit. This is simple case of date of birth. Birth certificate was issued by the health department. So, report is nothing.
you have the records.
the record is not with me, Lordship. On last day, Lordship, the direction for
No,
filing.
produced before the court
Earlier.
at one point of time.
On next day, Lordship, I will again produce if required, Lordship.
All right.
We'll fix it when? 4th December?
Any day.
Heard
Subject
Mr.
of-
Dasgupta, learned senior counsel appearing for the rate petitioner. Also heard Mr. P. Nayak, learned standing counsel GMC, who submits that affidavit has not yet been filed on behalf of the department. Mr. Dasgupta submits that this rate petition can be decided on the basis of the records, and therefore the rate petition be fixed for expeditious disposal. After hearing the submission of learned counsel for both the sides, this writ petition is directed to be listed again on 4th of December 2023 as a fixed item for admission. On the next date, the departmental records will be produced by the learned standing counsel GMC.
Item 21.
May I please, your Lordship. Lordship, matter pertains to recruitment in the post of sub-inspector unarmed branch in the police department, my lord. There is a, my lord, the petitioner here appeared against the advertisement dated 11/4/2018. Thereafter, on 15/2/2021, result was declared. Thereafter, having some doubt, he made an RTI application for the OMR seat and the answer key. Then he came to know that for question number 86, the authority has said it has option A in the written test, but he answered as option B. But according to the petitioner, both answer A and B is correct, my lord. Thereafter, his half mark was cut in the for the negative marking. But if he is allowed for 1.5 mark, he will exceed the cutoff marks, my lord. That is the case of the petitioner here. Thereafter, the respondent has filed their affidavits. In the affidavit, they had impliedly considered if they, if your lordship have a look at page 81 in their affidavit, my lord.
Just 1 minute.
My lord.
They broke your university.
So cutoff mark for OBC was 103.
No, my lord. As per the affidavit filed by the respondent number 6 and 7, the cutoff mark for the OBC category is 102.21.
And how much did your client secure?
My client secured 102.09, my lord.
All right, now, in one of the questions, that is question number 86.
Yes, my lord.
The question was Assam shares interstate boundary on eastern side with your client has answered
As
Arunachal.
Arunachal Pradesh, but as per the setter, it is at Manipur. But according to the petitioner, both is correct because
Assam shares boundary with Manipur.
Manipur is in the eastern side, Manipur and Arunachal both, my lord.
Arunachal is okay, but Manipur little down.
So which is the correct answer?
As per the map or as per the Assam's official website, my lord, both is correct.
But you have been marked half negative.
Yes, my lord.
So according to you,
I will get, if it is correct, then I will get 1.5 marks extra, my lord.
why 1.5 marks?
Because half mark has been deducted. That half mark, I will get that. And more 1 mark I will get for the correct answer, my lord.
So then in that case, your total will go to?
Total will go to, my lord, 103.59.
Right. And what they have admitted in the affidavit?
Yes, my lord.
Where is it?
At page 81, my lord.
Page 81.
Para 3, my lord. That before adverting to the contentions made in the writ petition, the deponent begs to state that if for the moment it is assumed that the contention of the petitioner is correct, though not admitted, even then the petitioner would not be able to secure required cutoff marks of the selection process. If the contentions of the petitioner were to be correct, he would have secured an additional mark of 1.50 marks in the written test section, which would yield his total marks in the written section to be 47 marks instead of 45.50 marks. But as per the advertisement, only 50% marks was to be calculated during the preparation of the final merit list. This is incorrect. Accordingly, 50% of 47 marks would be 23.50 marks and that of 45.50 marks would be 22.75. The difference of marks, if the contentions of the petitioner were to be correct, would increase his marks by 0.7 marks only. Even if their contention is considered to be correct, if my marks is also increased by 0.75 marks, then also I will be considered, my lord. As mentioned in paragraph 6 of the writ petition, the answer was missing the cutoff marks for about 0.91 marks. That 0.91 marks missing, it is all about regarding to the total 100 marks, my lord, 100%. They have make it at 50%. So obviously that will be a below of 0.91, my lord. Thus, it is apparent that the petitioner would still fall short of the 0.16 mark. That is wrong, my lord, to meet the required cutoff mark. My lord, yes, para 6, my lord, at page 82, that with regard to a contents of paragraph 2 of the writ petition, the answering deponent states that Dibrugarh University conducted the written test 100 marks and computer-based test 20 marks only. The physical standard test, PST, physical efficiency test, PET, verification of documents for extracurricular activities, verification of documents for computer academic, and verification of any other documents have been done by State Level Police Recruitment Board, hereinafter referred to as the SLPRB, and marks accordingly also have been given by SLPRB as per the advertisement published by the SLPRB in connection with the recruitment of Sub-Inspector Anam in Assam Police dated 11/4/2018. The marks for selection of candidates were allocated in 4 heads: written test 100 marks, physical efficiency test 40 marks, proficiency in computers 30 marks, extracurricular activities 30 marks. Furthermore, as per the said advertisement, the final merit list was to be prepared with the following criteria. Written examination 50% 100 marks, extracurricular activities 15% 30 marks, computer proficiency 15% 30 marks, physical efficiency test 20% of 40 marks. My lord, this 200 marks, the whole list was to be prepared according to 200 marks, but not about 50%, because this 50% of written test is categorized as 200 marks, 50% of 200 marks is 100. Means in the written examination, 50% of 200 marks is 100. 15% of 200
All right,
marks.
all right. Some people have worked so hard to make a very simple thing so complicated. I have not followed anything. What 100 mark, 50%. Have you made a chart?
Yes, my lord.
Show us. Where is the record?
My lord, in my affidavit,
Have to get the records.
in my rejoinder affidavit,
Have to get the record, Lordship.
Get it in 1 hour. Get it.
In 1 hour, Lordship.
Yes. Why the matter is fixed? Why the record is not there?
No, we have filed one, basically that will not help, Lordship, because this, what we have stated, the obese, the cutoff marks is Lordship 102 for OBC, Lordship. Yes, equal to 102.9. So that is the thing, Lordship, but in regard to that answer key, whether the state, which state counts on the eastern side of Assam, that specific instruction Lordship we have to get, Lordship. In regard to, because it is his person. It is his
What
person.
instruction? You have already filed affidavit. After filing
Guwahati
affidavit,
University has filed, I think. Guwahati, that.
yes, Guwahati University.
The Dibrugarh University has filed.
Dibrugarh University.
and you are appearing for who?
For board, Lordship, state level police recruitment board.
From 2021, they are not filing their affidavits. Court has already
All right, all right. Who's the person? Who's the concerned officer?
I appear for the university, madam.
You have filed your affidavit.
I filed my affidavit. The
Who's the chairman of the state level police recruitment board? Is there a register of that board? Or a secretary? Who has engaged you, Mr. Burua?
So the nodal officer is here of the board, Lordship, but the name.
All right, you give us his name. We'll give a date. If the affidavit and records are not made, then he will personally. After 5 to 10 minutes, at 12 o'clock, we'll call up. Give me the name of that officer, who is the secretary or register. And
All Lordship may kindly fix the matter at 2, Lordship. I'll get.
no, 2 is long time. Let's see what happens at 12. You just find out where are the records, who is to produce the records.
Okay,
We'll ask him to produce it or remain personally.
It's the answer scripts and all were evaluated by the Dibrugarh University. That part of the record would perhaps be with the Dibrugarh University.
No, that you have already said. The two answers,
2 answers.
both are correct. That's already said. So now, assuming that these 2 are correct, the negative marking has to be removed, and he has to be given 1.
Yes.
So he gets 1.5 mark.
1.5.
Now that has to be. If 1.5 mark is added,
My bad.
then what is his position? They are to state that by filing affidavit. You take down heard Mr. B.M. Deccan, counsel appearing for the petitioner, also heard Mr. R. Majumdar, learned standing counsel, Dibrugarh University, Assam. Are you standing counsel? Appearing for respondent number 6 and 7, who has invited the attention to the counter affidavit filed by the university, wherein it has been stated that both the options A and B in respect of
We have not said that both A and B are correct. We have said only A was correct. He did not put in A and therefore the B part is wrong. That is very specific, my lord. The wrong page was.
No, but
identified.
Assam, there is a border with Arunachal Pradesh also.
My lord, the border is there, but my lord, the interest on the eastern side is what was required to be taken into account. The setter of the question, my lord, who gives the answer along with the question. To his reasoning, it is the correct answer is Manipur. So therefore, my lord, my lord, whatever be the factual question or what is the correct answer, I am not on that. My lord, the only the observation that we have admitted in the affidavit that it is that both are correct may not be taken.
You're right. You're right. But how do we know which is the correct answer?
My lord, I had gone through a few judgments relating to such type of, my lord, through answer keys where 4 options are given, maybe 2 are correct, maybe something else is correct. It is at best left to the experts in that particular field. Now, here, my lord, in our affidavit, we also stated that the question setter has given reference to the Assam government website to show which answer is correct, or what the Assam government has given in their official website. Taking a cue from that, my lord, he has given the answer. Whether this court would be in that position to decide whether this is a correct answer or not, or whether it has to go to some, do not know, my lord, there are official.
Who is the expert to whom it can be sent?
If your lordships have a look at my annexure 12 at page 71, the map of the Assam.
No, we are not, I'm not, the
My
court
lord.
is not going to say.
That is what.
Which is the correct, which is the option, what is the option available?
If we can have some response, perhaps, I do not know, whether the political department or some department may say that yes, these are the boundaries we consider.
No.
Otherwise, my lord, there is no other expert in the field who can say which is the correct answer, except the question setter. Because a reference has been made. As per the official website of the government of Assam, the states situated on the east side of the Assam are Manipur and Nagaland. He has referred to an official website of the government of Assam. As Nagaland has been excluded from the 4 options, therefore Manipur is the correct option. That is the logic of the question setter. We can only go by the marks scored for the option given. That is what we can only do. And the calculation part, whether it was 50%, 20%, 100%, that can come later on, if only they are correct. That can always be corrected if we have made a wrong submission. That I'm not on. But how do we decide whether the question setter is correct or not? Would it be
What
upon
is the way
university? Let him suggest some manner in which we can do it.
My lord,
You also don't know. So you have not thought about it.
I'll leave it to your lordship in that.
Nothing, you leave it to me, I'm dismissing it.
If my lord, if
All
your
right.
lordship have a look at
That
the
was
page,
it.
at the official website of the Assam government.
Mr. Dekka, it doesn't happen like this.
My lord.
You may not be aware. The judge will not decide which is the correct answer.
I understand, my lord.
What is the way forward? On the request of Mr. B.M. Dekal and counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable him to.
My lord, it's a
determine
long pending, my lord. Maybe 1 week, my lord.
1 week. So as to enable him to obtain updated instruction, list accordingly. You write Mr. C.K.S. Burwal, learned E. Assam, and Mr. R. Mazinda, learned S.C. Dibrugarh University, are present on behalf of the official respondents.
I'm obliged.
Read. The last word, yes.
No, the date may be fixed, my lord.
After 1 week as a fixed item. No, but you have to come prepared. You are not at all prepared. You have just gone by some printout and then that's all. This is not going to do. You have to give us what are the precedents, what is the law, what is the way forward. Otherwise, we'll close the matter. There are hundreds of wrong answers, wrong questions. We are not concerned with that. We will go by what is the legally correct procedure. You
My
are
lord,
not able to say anything.
I'll try to find out, my lord.
Yes, otherwise we'll close the matter next day. We are not going for a witch hunting here. Maybe this is correct, that is correct. But and what about even if you succeed, are vacancies available?
Yes, my lord.
One post is
In the interim, 1 post was.
Item 22.
Not so much.
Lordship, the petitioner before your lordship is a peon lordship of Guwahati Municipal Corporation. Lordship, he was absent from duty from 15/9/2018 to 6/1/2019. Lordship.
It is a decision, I think,
Lordship,
3 days
decision-
back.
Decision we have, let's find out, but factually.
Last week only one decision was there. Are you aware? I am not sure whether it's Supreme Court or any other High Court's decision, but there is a decision. Disciplinary action on the ground of absenteeism is a valid ground.
Lordship, my case is something different.
All
Lordship.
right.
Lordship, after recovering illness, Lordship, on 7th, I have applied for regularization of the leave as well as allow me to join. The authority did not allow me to join, and rather I was referred to the medical board. Lordship. And the medical board opinion of the medical board is that at this stage he was fit for joining. Thereafter, they have regularized
So what is the period during which you were sick? Your client was sick?
Lordship, sick period 15/9/2018 to 6/1/2019. And that period was regularized on 9.
Around a little less than 3.5 months.
Yes, Lordship.
What was the ailment suffered by your client?
It is piles and something, Lordship, medical and other documents they have annexed, and subsequently that period was regularized by the authority.
Right.
And that is 19/12/2019.
Hmm.
After recommendation of the medical board, Lordship, the period from 15/9/2018 to 6/1/2019, that has been regularized.
Then what is the issue now?
Issue is, Lordship, subsequent to the regularization, because on 7/1, Lordship, I have filed an application, submitted the application for allowing me to join, Lordship. They did not allow me to join. They referred me to the medical board. After recommendation of the medical board event, they have not allow me to join, Lordship.
Achha, till date they have not allowed you to
No,
join.
subsequently, Lordship, the period from 7/1/2019 to my date of joining, that is, Lordship, 5/1/2021. For that period, Lordship, they have issued a show cause notice, Lordship, because I was the allegation is that I was willfully absent from duties. During that period, Lordship, I have submitted at least 3 applications for allowing me to join. They have
So
not.
now your client has joined service.
He has joined, Lordship.
What is his date of retirement?
Date of retirement, Lordship, it is.
No,
I have to find out.
approximately?
Approximately, Lordship, perhaps 2-3 years maybe there.
Achha. So what is the relief you are seeking here?
Relief is that, Lordship, as I have made a reply to the show cause notice. Thereafter, taking up a particular sentence, Lordship, they have passed an order that I have, Lordship, pleaded guilty. Therefore, penalty was imposed, and
Which is the particular sentence?
was, Lordship, as per, Lordship,
Which page?
Page 56, Lordship. So cause is page 54, Lordship, and statement of allegation is at page 55. Remain absent with effect from 7/1/2019 till date, after availing the commuter leave with effect from 15/9/2018 to 6/1/2019. The sentence they have taken up is that in the second line, Lordship, from middle, as per charge, the statement of allegation is true as such frame against me. And thereafter, Lordship, page 57, the consequential order is there. Peruse the written reply in respect of disciplinary proceeding drawn against Dipendas peon so and so. The charges of gross negligence of duties, indiscipline, and insubordination has been admitted by him. So and so, hereby allowed to join his duties with immediate effect, and the period of unauthorized absence from 7/1/2019 till date of joining treated as unauthorized leave without pay, Lordship, for the purpose of like increment, leave, etc.
So it says it is hereby dropped and disposed of. Disciplinary case is withdrawn. and
No,
it
that is not. Language is it is dropped and disposed of accordingly.
If it is dropped, you can impose the penalty. Mr. Bora,
He says that drop
you
and
are
disposal.
the trap you had set for the petitioner has got your own official into the same trap. You are picking up a line from his reply to say that he has admitted. All right, but you have dropped it. The proceeding has been dropped.
Oh. The authorities were lenient in that case, my lord.
No, but after dropping, you can impose a penalty.
What is drop? What use is drop, my lord? That is absolutely a melon.
And then
But
it
only
is dropped, then it is dropped.
let me go through some decisions, my lord.
Some decision.
No, if there, what is this drop, my lord?
How much time you want?
Next week, letter.
Yes, but dropped is dropped. The order penalty will be set aside. Heard Mr. UK Kalani counsel for the petition also heard Mr. S. Goran standing counsel GMC authorities appearing for the respondents. It appears that the proceedings drawn against the petitioner was dropped by the order dated. Which page is the order?
57, Lordship.
By the order dated
5/1/2021.
5/1/2021 passed by the Commissioner GMC Guwahati. Notwithstanding the same, an order of penalty
Yes,
has been served upon the petitioner based on the aforesaid disciplinary proceeding, which exercise prima facie appears to be dehoves the sanction of law. Mr. Bora, however, seeks 1 week's time to examine the legal issue and address the court. In view of the above, let this matter be listed
to consideration for appointment of the petitioner's lordship. Lordship, the petitioners herein were surrendered militants of a banned military organization, and they have surrendered in the year 2000. In that time, lordship, there was a provision for appointment in any grade 3 or grade 4 vacant post, lordship, and other candidates like the petitioners were given appointment. The pursuant to that, lordship, and nothing has been done, lordship, the petitioners approached the honorable court. The honorable court had issued a direction to consider the case of the petitioner, lordship. That starts at page 53, lordship.
Page 53.
Lordship. And
Yes.
operative part is at page 56, lordship, the direction.
Same petitioners.
Lordship.
Yes.
56 is the direction part, lordship.
Yes.
Lordship, thereafter process has been initiated, lordship. We have filed representations and one letter was issued on 4/5/2020, page 61, lordship. 61, lordship. May I read the letter, lordship? From Joint Secretary to Under Secretary Government of Assam, subject judgment order of Honorable Guwahati High Court in WPC 5456 regarding rehabilitation of surrendered militants. Reference letter number so-and-so dated 8/11/2018. Sir, inviting a reference to a letter on the subject cited above, I am directly forward here with a petition received from so-and-so and others requesting the government for employment in a grade 3 and grade 4 vacancies in the establishment of PWD building on the strength of the judgment order passed by the Honorable Guwahati High Court in WPC number 5456/2023, so-and-so versus so-and-so. Government in the political department has recommended for consideration of their cases by way of condonation relaxation of their ages for the post applied under the PWD in the light of the order of the Honorable Court. He felt the approval of the Honorable Chief Minister. Lordship, the process has been initiated, lordship, regarding their appointment and vacancies were identified. But thereafter, lordship, the respondents have issued a letter which we have challenged in this writ petition, page 64, lordship. Dear lordship, it was issued by the Joint Secretary to Government of Assam. And it was stated that to submit formal proposal for rehabilitation of petitioners through specific schemes and project under the Swavadambam scheme, along with financial implication and availability of budget under the appropriate head of account the current financial year 2021-22. Lordship, the respondents have inclined to bring the petitioner under some scheme, lordship, although there was a direction to consider for their appointment, lordship, and the process was initiated in that way regarding appointing them and giving them appointment in grade 3 and grade 4 posts, and vacancies were identified, lordship. That is my case, lordship.
No, where is the scheme? Can you just show the scheme?
Lordship, earlier there was a page 46, lordship, there I have annexed one scheme, lordship. Page 46, there is a revised scheme for surrender from rehabilitation of militants in North.
So where is the clause regarding government employment?
The note is there, Lordship, page 48, Lordship. Note 2, page
Yes.
48.
Hmm.
In the event of a surrender being able to secure any government job, earlier in the central government, PHU.
Not earlier, either.
Either, Lord, sorry. Central government, PHU, army, state government, cooperatives, where the central oblique state government has a share, this amount will not be given to the surrenders.
Lordship, earlier they have not received any amount. Lordship.
No, where is the provision in this scheme to give government job?
No,
Lordship, there, at that time, there was a provision, Lordship, they were given the similar situated candidate, they were given, I have annexed one letter, Lordship, with this regard. Page 39, Lordship, the same similarly situated candidates were given employment, Lordship.
No.
In the event of coming back to the mainstream of society, Lordship. Page 39 is the type copy, Lordship. Page 39 and 42 also. 42 is the order, Lordship.
See, you are not ready to argue this matter, and I'll tell you why.
Okay.
Employment in government job cannot be given dehouse the rules.
Okay.
If the rule prescribes a age limit,
Okay.
anybody who exceeds it cannot be employed. So first you have to give us a table of the people, what is their age as on today. If they've exceeded the age, they cannot be employed.
Yes.
This is point number 1.
Okay.
Number 2, there is no such scheme that they will be given government jobs. Somebody was given somewhere a job,
Lordship, at that time.
that cannot be a ground for the court to. So you have to make out a case on your own facts and own merit. The learned judge only says suitable relief and rehabilitation.
Lordship.
That they have already got.
Lordship, they have
So
not
for
got
that,
any
this
relief.
letter dated 4th January 2022. This is for suitable relief and rehabilitation only.
Lordship, prior to that, Lordship, there was a letter, Lordship, their case has
But
been.
that is a mistake. That's a wrong thing.
Lordship, records are called, there also.
No,
Lordship,
this
it was
type
just
of
pending
directions
for
cannot.
cabinet approval, otherwise all the departments have cleared.
It cannot be done. The cabinet approval is wrong.
Lordship.
There is no such direction, and this kind of recruitment cannot be made. Of course, all that the scheme can do is relax the norms of selection. They may not have to be sitting in a recruitment test. These things can be done. But if the qualification, age bar, other things, that cannot be relaxed.
Lordship.
Even the cabinet cannot do it. The court cannot do it.
Lordship,
Cannot
on
be
the,
done. That's why I said you are not prepared today to argue the case.
Lordship, on the last date, there was a direction to the standing council to bring the updated instruction, Lordship, regarding the matter, if anything could be done, Lordship. They have the instruction.
Lordship, yet to receive, Lordship.
You saw the reaction of the court and caught hold of it immediately. But the personal appearance will now be directed.
Lordship.
Why you have not
let-
got instruction on this
let-
4th January letter?
Lordship, let me make a try, Lordship, honest try, Lordship.
No, this attempt you have been making since.
Lordship, they have filed their affidavit.
Yes, we had filed our affidavit. We are clearing our stand, Lordship.
What is your stand?
Yes, stand is that, Lordship. Rehabilitation is there, Lordship. That part is open, but regarding the appointment, Lordship, their age, they are over age, Lordship, 54, number one, 51.
They cannot be given government employment.
Yes, Lordship. Therefore, this stand is, our stand is clear, Lordship.
What is the rehabilitation you are doing? They have surrendered in 2000.
In animal, already they got something. I think they got. Lordship, we have similarly situated. We have some scheme. It means Sabolamban scheme is there, Lordship, and it is in PNR, Animal Husbandry Department of PNR, Lordship, for doing something, Lordship.
No, there's something, nothing is going on since several years. Let the officer come with the records.
They will easily got all these things, Lordship. We had already sent a letter, Lordship. The process is going on, Lordship. Regarding.
No, but how long will it take? Another 10 years?
No, Lordship. It will. Lordship, I will take the instruction.
Heard Mr. Talukdar and counsel for the petitioner. Also heard Mr. J.K. Goswami, who has once again submitted that some process is going on to rehabilitate the petitioners, but he does not have the complete instruction in the matter till date. The issue involved in this writ petition dates back to the year 2000, when the petitioners had surrendered as extremists, and their prayer for rehabilitation has not yet been finalized by the government, despite the order passed by this court. Be that as it may, on the request of Mr. Goswami, this writ petition is directed to be listed again on 6th of December as a fixed item, so as to give him one final opportunity to obtain complete instruction. Miss M. Das, the counsel is present for response number 4. Employment is out of question. Don't even think of that.
Regarding other rehabilitation.
What is happening? We want that to happen as early as possible.
Lordship.
If you've given them an assurance, you have to complete.
Lordship.
Making a promise, you have to fulfill it.
Yes, Lordship.
Don't make a promise if you can't fulfill it.
Lordship.
Much obliged.
This matter has become infectious because my lord.
All right, Mr. Yasnath, counsel for the petitioner submits on instructions from his client that this matter has become infectious and can be closed. Mr. J.K. Goswami, additional senior government advocate Assam, is present on behalf of the state and suppose the said submission. In view of the above, the writ petition stands disposed of as in process.
Item 26.
May I please, Lordship? Well, here the petitioner challenged the appointment of the private respondent as Gar Pradhan, madam. And because he is involved in one of the criminal cases and a charges had not been filed, madam.
Then you have preferred an appeal.
No, appeal has not been preferred. My Lordship will give me liberty to refine appeal, madam. That's all.
Right.
So there's a provision for it.
Petitioner herein, you heard Mr. S. Bora, learned counsel for the writ petitioner, also heard Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the respond numbers 1 and 3. Mr. S. Datta, learned SC Revenue Department Assam for respond number 2. No, 1, 3 and 4, huh? Mr. Datta for respond number 2 and Mr. UK Das, counsel for respond number 5. The writ petitioner herein was one of the candidates for recruitment of Gaon Pradhan for the for the
Uttar Bozali, my lord, this is Moza.
What is the name of that?
My lord, let's still find it, page number 31, last page, my lord. The selection list, my lord.
For village Bordang, Moja Uttar Bazali, charge oblique lot number 23 in the district of Bajali, Assam. However, the petitioner did not, Bajali, Assam, in terms of the advertisement notice Later you give it in the beginning. In terms of the advertisement notice dated
23, page number
23,
15.
3, 2022, the petitioner had submitted his candidature for selection and appointment to the post of Gaon Pradhan in respect of so-and-so, so-and-so, so-and-so. However, the petitioner did not emerge successful. On the contrary, it is the respondent number 5 who has been selected, already appointed,
Elected, my lord. Appointed,
already
my lord.
appointed
Working
and appointed as the Gaon Pradhan in respect of the said village.
and criminal case is going on against him. my lord.
Assailing the selection of respondent number 5, the petitioner has approached this court internally contending that there is a criminal case pending against the petitioner and therefore he was not eligible to apply for the post of Gaon Pradhan. Full stop. The Mr. S. Datta Leonard, Standing Counsel, Revenue Department, Assam, on the other hand, submits that the issue can be agitated in an appeal referred under Rule 164
2C.
162 capital C of the executive instructions framed under the Assam Land and Revenue Regulation 1886, and therefore the writ petition be dismissed on such count. Similar is the stand of Mr. U.K. Das, learned counsel for the private respondent. At this stage, Mr. Bora seeks leave of this court to withdraw the writ petition with liberty to prefer appeal before the competent authority. Prayer allowed. Prayer allowed. The petitioner is granted liberty to prefer appeal before the competent authority, which will be entertained subject to proper explanation for delay in filing the appeal being submitted by the petitioner. The writ petition stands disposed of accordingly.
Okay.
Item 27.
Please, my lord, here the petitioner is aggrieved by the premature retirement which has been imposed upon him by the Assam Rifles with by referring to FR 56J and CCS 48(1)B, my lord, which requires them to retire 20 years of age. But they had based it on the medical ground, my lord. Similar repetitions had been disposed of by this honorable court and also by the Meghalaya High Court, my lord, setting aside all such retirement orders. Respondents have also come up with a policy saying that in future we will not retire anyone. However, for those who had already retired by the time, only with a court order they would be reinstated in service is their policy decision. We are against that. If the
I have filed my affidavit, Lordship. Kindly fix another date, Lordship.
Just one.
Today I am not prepared.
Page 91, my lord, of their affidavit of opposition.
Where is the decision of the court, earlier decision?
My lord, earlier decisions of the court, lordship would find page 25 onwards. Relevant portion starts at page 29. The judgment starts at page 29 and at page 38 is the effective portion. Para 23. Or if I may read from page 37, para 27, 22.
So is this covered under this judgment?
They admit so, my lord.
Huh?
Yes, Lordship.
You are laughing. Well, give me the answer.
Yes, Lordship, covered. Covered, Lordship.
Covered. Then we'll allow the writ petition.
Yes, sir. Kindly fix another date, Lordship. I have to go, so I am not prepared today. And sometime required, I have.
How long will it take you to prepare?
No.
Mr. Ahmadinka, learned counsel for the
Next week.
writ petitioner who submits that his case is covered under the previous judgments of the court and therefore the petition be allowed. Mrs. Burwal and CGC, on the other hand, have prayed for posting this matter again in the next week so as to enable her to go through the records and address the court. On the request of Ms. Borwa, let this matter be listed again in the next week as a fixed item.
I'm obliged.
Date may be fixed.
calculate the date from today, next week. Fixed item means exactly after a week.
Item 28.
May please also. But in this case, the petitioner with Lossi was initially appointed as one of Gram Rozgar Sahayak Malad on 1/3/2016. Subsequently, one of his service, contextual service was terminated. And Malad, after termination, Malad, he approached this Honorable Court. And this Honorable Court, Malad, passed the order at page 21.
Yes.
Page 21, for the court's order, my lord. Relevant portion, page 24, my lord.
Yes.
Last paragraph, my lord. In view of the discussion made herein above, this petition succeeds, and accordingly, the communication dated 1/7/2016 written by the respondent number 4 and the order dated 12/8/2016 passed by respondent number 5 are set aside and quashed. The respondents are directed to forthwith reinstate the petitioner back into his contextual engagement. So the direction of the Honorable Court, my lord.
Yes.
Thereafter, my lord, the joint director, my lord, by letter dated 12 June 2018, page 25, my lord, directed the project director to reinstate the petitioner in his service. What the project director did, page 26, I was reappointed. I was not reinstated. For this, my lord, reappointment, I am not getting the benefit at case 27, my lord.
Yes. He has to come because he is apparently acted in.
Lordship reappoint, in annexer 6 here said, he has reappointed with reference to the Guwahati High Court order passed in WPC 4462/2018. This was another matter. Lordship. So.
Another matter, which order is that?
Lordship, we have already reinstated him for the.
Where is the order of reinstatement?
Reinstated, Lordship.
Page 26, my lord.
Lordship, page 25, reinstated.
Page 25.
Page 25. Then he silenced this order. So this.
Which is this WPC 5611?
My lord,
That's a
I
bit-
was posted in a different block. Initially, I was in Vidya Jajikona, my lord. I was posted in a different block on my lord reappointment. I challenged that order, my lord, for posting me, my lord, in a different block. That was dismissed. My lord. So, my lord, I had to join in the new block. This has nothing to do with the reinstatement.
So according to you, everything is all right.
Lordship, we have already.
Then we have no other option. Project director should remain personally present. To explain, heard Mr.
Lordship, we have already filed our affidavit.
Not interested. There is an order of the court to reinstate. Why have you reappointed him?
Reappoint means already we have reinstated him, but
Where is the order of reinstatement?
page number 25.
All right, so you have finished whatever you have to say, but this is nowhere near to what the court is asking. You are not prepared and you are not taking the court's queries seriously at all. You are
No,
just
that's-
saying whatever you feel like.
Lordship, we have.
Who is the
rein-
project director? Take down, heard Mr. Ayed Saikel and counsel for the writ petitioner. Also heard Miss N. Bora, Land Standing Council, PNRD Assam, appearing for the respondent numbers 1, 2, 4 and 5. Mr. J.K. Goswami, Learned Additional Senior Government Advocate Assam, is present on behalf of the respondent number 3. First up. The writ petitioner herein was originally engaged as a MIS, block MIS manager under the District Rural Development Agency, Kamrup, bracket IAY, bracket close, on contractual basis. However, by the communication dated 1/7/2016 issued by the Block Development Officer Bazara, that is the respondent number, Block Development Officer Bazara, he was informed that his services had been terminated. Aggrieved thereby, the petitioner had approached this court by filing WPC number 5611 of 2017, which was allowed by the learned single judge by order dated 14/5/2018. The operative parts of the order may be noted hereunder. Page 24, double tick to double tick. Question. Pursuant to the order dated 14/5/2018, passed in WPC number 5611/2017. The respondent number four, that is the project director, DRDA Kamrup Amenga, had issued order dated 16/11/2018, reappointing the petitioner. Although the direction of the court was to reinstate the petitioner after setting aside the termination of his service. The order dated 16/11/2018 also refers to another proceeding in the form of WPC number 4462/2018, which had nothing to do with the order of reinstatement of the petitioner. Situated thus, this court had requested the learned departmental counsel, Ms. N. Bora, to explain the position. However, the learned departmental counsel could not give any answer which is even remotely relevant for the purpose of the query made by the court. Under the circumstances, this court is left with no option but to direct personal appearance of the respondent number 4 to explain the matter. As such, the respondent number 4, that is the project director, District Rural Development Agency, is directed to remain personally present before this court on the next date fixed. Let this writ petition be listed again on 20th of December 2023 as a fixed item. Office to communicate this order to the respondent number 4 through special messenger. In addition to that, a copy of this order be also furnished to Ms. Bora, Learned Department Counsel, for necessary action. You are unable to give any answer to the court. Now onwards, every case will direct personal appearance. You can't run things in this manner. When the court says reinstate in one matter, by referring to another writ petition, he is being reappointed and you don't have any answer. You are saying you filed affidavit.
Lordship, we have already filed our affidavit.
All right, all right.
Item 29.
Yes, my lordship. My lord, here removal from service after 32 years of continuous service, regular service, my lord, and allegation is for, my lord, that anomalies for about 14,000 only. A tribal person, my lord, from Karbi Anglo. So it should be hard, my lord.
When?
My lord, the.
Affidavit has been filed.
My lord?
Yes, my lord. It has been filed.
Readings are complete.
Yes.
Mr. R.P. Sharma, Learned Senior Counsel, assisted by Miss
From the Vijaya Das.
Vijay Das has appeared for the petitioner. Mr.
K. Vishwakarma.
K. Vishwakarma and a counsel is present on behalf of the respondents. It is submitted at the bar that this matter is ready as regards service and pleadings and therefore can be fixed for final hearing. Taking note of submissions made by learned counsel for both the sides. This writ petition is admitted to final hearing, registered to list the matter in the second week of January 2024 as a fixed item for hearing.
Obliged.
Item 30.
My lord, in this case, just today I have been engaged. Kindly fix another day in the next week, my lord.
Mr. M.O. Mohammed, learned counsel, submits that he has recently been engaged, or he has been engaged as the petitioner's counsel only this morning, and therefore some time be granted to seek instruction and argue the matter. Mr. J.K. Goswami, learned additional senior government advocate Assam, is present on behalf of the state. On the request of Mr. Mahmood, let this matter be listed again after 10 days.
All right.
Item 31.
So I don't know how to start. I feel a bit embarrassing because 23 matter, 23. And we said that this man is getting superannuated in 30th of November. Some indulgence was given with respect to the, by this court, say all the pleadings has to be completed. So according pleading has been completed. So he's going to retire on 30th of January. There were two prayers, one prayer we have left, 30th of November. We are not pressing that regarding promotion. Court said we'll keep that particular promotion, that will be subject. That is meaningless, my lord. Is only what you are worried about the all affidavit, everything is filed, my lord, in this case. So
This has to be taken up for disposal.
yes, my lord. That's I don't know, my lord. This is
No, no,
23.
all
Yes, but I just humbly submit before lordship if it is not inconvenient. And to my learned friend, everyone wants before retirement. I don't know.
That's
what is
fine.
the-
When do you want it?
My lord, anytime before 30th of November, whichever is convenient, my lord.
All right, you tell us which is a convenient date.
last day. 30th is the last day. He said that it be fixed on 30th. Subject to, of course,
30th
convenience
is the last day of
retirement, superannuated he is getting. Only I'm worried of that. I don't know what will be the end result, my lord. It's very narrow campus, the matter is, my lord. Very, very narrow campus.
You'll get the
I'll show it.
benefit, my lord. If any, suppose it is hard in the first.
Why don't you argue today itself?
Yeah, I can argue. I can very well, I can argue.
Mr.
Absolutely no
Savala?
problem.
My lord,
You're ready today?
I'm not prepared in that way, my lord. Sorry.
I am absolutely informed.
On Tuesday, 28th?
28th.
Indeed.
He is. But if it-
Mr. Das and Mr. Saiwala, this court is ready to hear
know,
the
I'm
matter
ready.
today. In the second half, tomorrow, day after, you
Tomorrow,
agree on a day.
Tomorrow also, my lord. Tomorrow, let it be taken tomorrow. Tomorrow. Let it be tomorrow, my lord. Tomorrow, Kali.
Start,
Tomorrow-
in that case, you
tomorrow-
can start, no problem.
Yes.
No, there is no start finish. We'll
Yeah.
finish it off.
Tomorrow we will.
There is nothing to start and stop. These matters have to be heard and
I
finished
am
off.
ready with this case.
Tomorrow,
Tomorrow.
on the request of Mr. D. Das, learned senior counsel for the petitioner, and Mr. G. N. Saiwala, learned senior counsel appearing for the respondent, let these matters be listed again as fixed items tomorrow for admission hearing.
I'm deeply obliged. Deeply obliged.
Mr. Das, brief note.
I'll give a brief note.
Yes, that
I'll
will
give a
be
brief note, point for determination by the court.
similar from both sides.
Yes.
That will help me dictate the judgment in the court itself.
Yes, 100%.
Item 33.
Well, please, your lordship. My lord, the petitioner is an employee of Indira Gandhi Open.
Before starting, I have a paying for a 10 days at least.
So, my lordship will kindly peruse the last order.
Yes, Lordship, I'll let 2 occasion I have some time.
Suspension till last 1 year without any review, my lord.
Lordship, I'll take instruction within 10 days, Lordship only.
No, what is the matter about?
My lord, the petitioner has been placed under suspension under Rule 10 of CCA rules. And as your lordship knows, as per Rule 6 and 7, a review has to be done within 90 days. And if review is not done, the validity expires, my lord. So now 1 year has elapsed, more than 1 year has elapsed. No review, nothing, my lord, not even the subsistence allowance. And there is a lordship order 21/7/2023, your dishonorable court's order. 21/7/2023.
See, Mr. Patwari,
My lord.
we'll grant him 10 days time, but with a rider. If he fails to show that there was a review and it was communicated to the petitioner, then your client would be treated to have been reinstated with effect from the date on which that 90 days period had expired. And you will have to be paid the balance of arrears salary also. So 10 days or 7 days will not make any difference. But that's the law. You better come up clear on that.
Lordship, I'll clear.
And even
Otherwise, it is causing undue harassment to the people.
yes, more than
They follow the edict of
One
law.
is problem, Lordship. He was in a National Highway Department. The National Highway Department reported him to our parent department. There is some documentation also we are also collecting, Lordship. Anyway, Lordship.
No, what is the parent department?
Ignore, Lordship.
Indira Gandhi State Open University.
But his suspension was once he was with you.
Lordship. Lordship.
That 90 days review was done or not, you will know.
Lordship, I will take instruction on that specifically.
So you have to produce 2 documents.
Lordship.
One, that it was reviewed after 90 days, and second, that it was communicated to him.
Lordship.
Otherwise, we'll clarify the law.
Lordship.
And in Deepak
Your inertia cannot make people suffer like
Lordship.
this. If both the conditions are not met,
Lordship.
you will be deemed to have been reinstated with effect from the expiry of 90 days, and you will have to pay him his salary, whether or not he has worked. Get clear instructions from your clients on that.
Lordship.
There is no escape from these conclusions. We have had enough.
Lordship, we have.
There is a judgment of the Supreme
Yes,
Court.
yes, yes.
You're not following it. There are
Lordship,
decisions.
even
of the
yesterday
High
also
Court.
I have communicated to my clients, whatever the
Not
instructions we have.
communicated. Now they will have to face consequences.
Lordship, anyway,
You
10 days.
cannot see, because you are not complying with the court orders. There is a multiplication of litigations. Cases are coming to the court, raising dependency. There has to be some cost for all these things. This time there will be cost. Heard Mr. J. Patwari, learned counsel for the petitioner, also heard Mr. P.P. Datta, learned SC, IGNOU, appearing for the respond numbers
1 to 4.
1 to 4,
1 to
Lordship.
4, who prays for further 10 days time as final opportunity to obtain instruction
And to affidavit, Lordship.
and to file affidavit. Mr. D. Bora, learned
I am appearing on behalf of Mrs. R. Bora on for respond numbers 5, 6, and 7.
learned counsel has appeared for respond numbers 5, 6, and 7. On the request of Mr. Datta, this matter is directed to be listed again after 10 days as a fixed item, so as to give him one more opportunity to obtain instruction. On the next date fixed, Mr. Datta to produce copy of order of review of the suspension of the petitioner, if any, and also the documentary proof to show that the same was communicated to the petitioner.
Obliged.
Deeply obliged.
Not a copy or records to show that the order was reviewed, order of suspension was reviewed. And if so, documentary proof to show that the decision was communicated to the petitioner at the relevant point of time.
Deeply
Item 34.
The Lordship. My lord, here in this case, my lord, my only simple prayer is that, my lord, the selection committee is to be constituted as per Rule 11, and post of the vacant post of selection grade should be filled up. And kindly see rule, my lord, page 21. Page 20, my lord. starts from 11. Page 20. Appointment by promotion in the cadre shall be made in the manner provided hereinafter. Before the end of each year, the appointing authority shall make an assessment of number of vacancy occurred or likely to occur for filling up of the promotion in the next year in each cadre. Subject to suitability may decided the board and
So you want that process of promotion be expedited?
yes, because I am going to be retired in 31st of this 12/2023. Petitioner number 1.
And this is for which post? Additional secretary?
Page 37 can you see?
Which post?
Additional secretary selection grade.
How many vacancies are there?
That vacancy position 0.
No, you tell her, I will not see.
Only two. There are only 2 posts. 2 is vacant. Page 37 can you see? From
So,
2021.
So Mr. Nayak, he has a right to be fundamental.
Lordship, my affidavit has already been sent for vetting, Lordship. We are hoping that it will come very soon, Lordship. Lordship will take up
No,
after 2 weeks.
affidavit, we file it after January. But these petitioners have a right to be considered for promotion. That is a fundamental right.
Lordship.
You file your affidavit, explain why will you not do it. But in the meantime, you have to do it. Because if he retires, then he doesn't get a chance to be considered.
No, he is retiring in the month of December, Lordship.
Right,
1
that-
month is already, I'm praying for 2 weeks only, Lordship.
No, what is there in affidavit? Whatever you write, you have to constitute the selection level board and consider him. You promote him, you don't promote him, that is another matter.
Yes, Lordship.
You cannot let matters lapse like this without considering. This is a completely arbitrary exercise of power. These officials, whoever they are, they have legitimate expectation of being considered. There are vacancies. He is retiring. He is eligible. You are just waiting not to consider him so that
No,
the
Lordship,
investment-
we are, in fact, Lordship, the process is on. It is just because of ACRs and APRs have been received from the concerned officer under process that is awaited, Lordship. Once the ACRs and APRs are received, Lordship, it's completed, steps will be taken to hold the meeting of the selection board. So it will be soon, it will be taken, I hope, Lordship. So let my affidavit come, Lordship.
No, we'll fix it again on 1st December. Heard Mr. S.K. Ghosh, learned counsel for the petitioner, also heard Mr. P. Nayak, learned standing counsel,
Finance, Lordship.
Finance Department, Assam, who prays for 2 weeks further time to seek instruction in file affidavit.
Instruction I have received, Lordship.
To file
File
affidavit.
minutes, Lordship.
However, Mr. Ghosh submits that there are 2 vacancies in the rank of additional secretary selection grade in the department, and his clients, both of them are retiring.
One.
And the petitioner number 1 is retiring with effect from 31st December 2023. As such, there is urgency in the matter. Full stop. Law is by now firmly settled that right to be considered for promotion is a fundamental right. Full stop. Therefore, if there are, in fact, vacant posts of additional secretary selection grade, and if the petitioners are eligible for being considered for promotion, then the departmental authorities cannot refuse to consider their case by taking some technical grounds here and there. Although it is not clear as to what action the department has taken in the matter, yet it is expected that the authorities would take necessary steps so as to constitute the selection board for considering the cases of the petitioners, at least on a date which is prior to the date of retirement of the petitioner number 1. On the request of Mr. Nayak, this matter is directed to be listed again on 4th of December 2023, so as to enable him to obtain updated written instruction on the aforesaid aspect of the matter. You file your affidavit, but please tell us what is being done.
Lordship.
Lord, my only simple prayer is board is to be constituted, then matter may be considered.
Consider,
Only that
you find
much
them
prayer.
fit, you don't
I
find them
don't
fit,
have
that
any
is
much more
your
prayer.
discretion.
Lordship.
But you don't have a discretion not to consider them. I will clarify it. You can't do that. May I please, your lordship? Your lordship, on the last occasion, your lordship, the learned counsel for the government advocate, your lordship, has sought time to file affidavit in opposition. Till now, there has not been any.
Lordship, kindly accommodate 2 weeks time, Lordship, I will file.
Mr. T.S. Deka, your lordship, I am appearing.
Dekal, learned counsel is present for the petitioner. Mr. J.K. Goswami, learned additional government advocate Assam, has prayed for further 3 weeks time to file affidavit. Prayer allowed, that the matter be listed accordingly.
Much obliged.
Item 36.
The instructions are for here also, my lord, notional premise promotion, my lord, petitioner paid for notional promotion, my lord. Earlier it was due in the year, my lord, April 2020, my lord. But he has.
My lord, we have received the instructions. I pray for 2 weeks time to file the affidavit.
Stage, thus learned counsel is present for the petitioner. On the request of Mr. A. Burua, learned SCAPDCL, this matter stands adjourned for 3 weeks so as to enable him to file affidavit.
I'm obliged. I think obliged.
Item 37.
My lord, the petitioner was appointed, my lord, petitioner was working, my lord, in Assam State, my lord, Textbook Publication and Production Corporation. While she was working, my lord, she was sexually harassed, my lord. Then she lodged a complaint, my lord. At that time, there was no internal complaint committee. Subsequently, my lord, the petitioner approached this honorable court. During that time, they have constituted the committee. That itself is illegal as per provision of law, my lord. It should be chairman, should be woman, my lord. Instead of that, my lord, the one male person has been appointed as chairman. And subsequently approached this court, my lord, honorable court. The honorable court they have, my lord, submitted before this court that they have already initiated the proceeding. But my lord, directing the respondents to, my lord, complete the proceeding as per provision of law. Lordship has disposed it of your lordship's order is at page 40, my lord. Petition was disposed of. After that order, my lord, they have issued a letter to me to submit my written statement. After that, my lord, they have issued this letter at page 43 to, directing me to submit my written statement. And pursuant to this letter, my lord, I have submitted my written statement on 11/7/2023. Thereafter, they are doing nothing. Statutory provision, my lord, within 90 days from the date of filing the complaint, my lord, they have to dispose it of, my lord.
Yes, who is appearing?
Lordship, Lordship, the complaint committee has already submitted their report in the month of September itself. And they have concluded that as per the committee, no hard evidences were found against the complaint.
Can you communicate it to the petitioner?
Yes, that itself is a violation, my lord, as per law, my lord. Both the parties should be communicated.
What you do is, since there is already a report, we'll ask them to communicate to your client within a week. And you assail it.
My lord.
You assail it afresh.
My lord, but committee, lordship, your lordship, kindly see, my lord, section 4, my lord.
Nothing
Committees-
more can be done until and unless you assail that. You have to assail that report.
My lord.
Is it not? There you take all other grounds. But now the court has directed them to complete the proceeding. They have done it. Is it not? What is the relief you are seeking here?
Relief, my lord, lordship will find, my lord.
So reconstituting the internal committee, that's
Well-
what you want, a fresh inquiry.
My lord.
For that, you have to challenge that report. You're not understood.
But yes, yes, my lord, that is true, my lord.
So you are taking one technical ground by violating another technical norm. That's not going to work out. Earlier, the thrust of your case was that the committee is not doing its job.
Yes.
Right. But now they have done it. Rightly or wrongly, they have done it.
But that committee is illegal.
All right, we'll keep it pending. It will
No, my
further
lord,
delay
no,
your
my lord,
client's.
I am just, my lord, trying to convince your
Maybe,
lordship
but
that
until and unless you
this
challenge
is the
that
second
report,
time, my lord, this is the second time that is why.
can be done. You have to challenge that report. Or at least file an additional affidavit. But that too, I don't know. And the matter is heard whether. You
I
to
have
challenge-
challenged the committee, my lord, in this petition. But if that committee, my lord, submitted a report, that report itself will be illegal, my lord. That is my submission.
All right, heard Mr. N. Kalita, learned counsel for the petitioner, also heard Ms. M. Kalita, learned counsel appearing for the respondent numbers.
Lordship. Lordship 2, 3 and 4.
2, 3 and 4. Anybody appearing for respondent number 1?
No, sir, I am for the respondent number 5.
Mr.
DJ Boro.
DJ Boro, learned counsel is present for the respondent number 5. By filing this petition, the petitioner, who is the complainant of sexual harassment at workplace, has assailed the very constitution of the committee for investigating into the matter. First of when the writ petition is called up today, Ms. M. Kalita submits that the committee so constituted has already submitted its report in the month of September 2000. What is the date of the report?
18/09/2023, Your Lordship.
10/09.
18.
18 submitted report on 18/9/2023. Mr. Kalita, however, submits that his client has not received a copy of the report. In view of the above, the respondents numbers 2 to 4 are directed to furnish a copy of the report dated 18/9/2023 to the petitioner within 10 days from today. Thereafter, the petitioner will be at liberty to file additional affidavit if so advised. That the matter will be listed accordingly.
Highly agree, Your Lordship.
38.
May I please your lordships, in this case, lordship, though additional affidavit is directed to file lordship, actually, we have complied the order, lordship, kindly peruse.
Order has been complied with.
Actually considered and rejected, lordship.
Where is the order of rejection?
Or affidavit has been filed, lordship.
But where is the order of rejection?
As I hear, lordship, in Annexure B, lordship, order 20. Annexure B of my affidavit, lordship.
You've got a copy of the
affidavit received by.
You got it? So then you have to challenge this order now.
Lordship.
All right.
Lordship,
At
actually.
this stage, the Tamil Learned Council for the petitioners. Also had Ms. R.B. Bora, Learned BTC appearing, Learned SC BTC appearing for the respondent number 2, who submits that in view of the order dated 21/1/2023 passed by the respondent number 2, the order of this court stands complied with. It appears that by the order dated 21/1/2023, it is the respondent number 2, is it? Who has
Yes,
passed the order?
Yes.
The respondent number 2 has considered the case of the petitioners and thereafter has rejected the same. If that be so, it will now be up to the petitioners to assail the order dated 21/1/2023. With the following observation, with the above observation, this contempt case stands closed. You challenge it, we'll see.
Lordship.
If level.
Obliged.
Item 39.
Yeah, the lordship. Well, we have taken the steps, my lord, steps not returned. AD card not received any. Office not dated, my lord. 11/10/2020.
Mr. T. Seth, Learned Counsel for the petitioner. There was office note dated 11/10/2023. Await service report. Is the matter accordingly.
Item 40.
May I please your lordship? Lordship, according to order dated 21/7/2023, the respondents were supposed to file an affidavit to bring on record their statement stating that the handmade paper industry was shut down.
As for order dated
21/7/2023.
Yes, where is your affidavit, Mr. Munir?
Hello,
You have taken time.
my lord. My lord, you kindly.
No, we'll close, forfeit your right to file affidavit and post the matter for hearing. That's all.
The issue here, my lord, the petitioners are.
We'll hear that,
Oh, my-
but no affidavit.
Fine.
Heard Miss
A.H. Atiyar, your lordship.
A.
H. Atiyar.
A.H. Appeal, counsel for the petitioner, who has invited the attention of this court to the order dated 21/7/2023, by means of which the learned counsel for the respondents was granted 4 weeks time to file affidavit. Full stop. Despite the time granted by this court, no affidavit has been filed till today. As a matter of fact, even by the subsequent order dated 13/10/2023, 4 weeks further time was granted for filing affidavit. Mr. Munir, learned counsel for the respondents, is present but could not furnish any explanation as to the reason for not filing the affidavit. If that be so, the right of the respondents to file affidavit, respondent numbers 1 to 5, to file affidavit is hereby struck off. Consequently, this matter will now be decided on the basis of materials already available on record. This case for hearing after 3 weeks.
Much obliged, Your Lordship.
Admission hearing after 3 weeks.
Item 41.
No, I'm paying for respondent number 5, madam.
You have for respondent number?
5, madam.
None appears for the petitioner on call. Mr. C.K.S. Bora, learned government advocate Assam, and Mr. S. Bothakur, learned counsel for the respondent number 5, are present. Office note dated 17/11/2023 indicates that service of notice on respondent number 6 is also complete in this case. In view of the above, register to list the matter for admission after 2 weeks.
And after 3 weeks, madam, we'll file affidavit.
After 3 weeks, in the meantime, the respondents may file affidavit if so advised. Yes.
Item 42 and 43.
Pension matter, my lord. If your lordship kindly turns to page number 13, my lord, that is why the direction of this honorable court is. Page number 13, the last paragraph. It says, taking into account Rule 22 of Assam Service Pension Rules 1969 as well as the OM dated 21/6/2012, this court directs the respondent authorities to forthwith release the provisional pension to the petitioner. Well, I have not received the provisional pension, but I've been intimated that the sanction has been given.
Yes, my lord. Already
Yes,
the matter
you want
has
to
already been complied with, my lord.
Go to him.
I have been given a copy. Now, this is the order dated 13/3/2023, and on 16/10/2023, the sanction has been given. So, my lord, let them expedite and release the provisional pension.
The sanction, who is to now release it?
My lord,
We have already sanctioned, my lord.
they have
Lord,
written to the
affidavit is
AG.
sent for vetting, my lord. I have the instruction, my lord. That on 16th October, my lord, the GPF provisional pension and all the substances allowances has already been sanctioned, my lord. Except the DCRG, as the disciplinary proceeding is pending, all the other dues have already been
No, but he
sanctioned.
has not received the amount.
My lord, it was sanctioned on 16th of October.
Who is supposed to release the amount?
Animal husbandry
Animal husbandry department is the authority to release the provisional pension.
Provisional.
Final pension is the accountant general.
Accountant general.
The amount has not been released, so where is the compliance? The direction is to release the amount.
Release the amount.
Released amount, my lord. My lord, may I submit the instructions?
No, but you submit, but also submit the names of your officials. We'll have to summon them and ask them why the contempt of court proceedings should not be drawn. The direction is to release the amount, has not been
Released
released.
the amount, my lord. They have already sanctioned, my lord. 1 week time may be allowed. I will
Oh,
take,
we are asking you, release it. Sanctioning is your internal matter.
my lord.
The amount has to reach him.
Well,
it is
1
not
week time
reached.
may be allowed. I will give the
All right, one
instruction.
last chance, otherwise
My
personal
lord.
appearance.
My
But
lord.
Mr. A.K. Borwal, learned counsel for the petitioner, also heard Miss M.
Kotoki.
M.
my-
Kotoki, learned counsel appearing for the.
Animal husbandry and veterinary department.
No, this is contempt case. Respond number.
My lord, in contempt case, I am not appearing, my lord.
Animal
In the
Husbandry
writ
and
petition, I have.
Veterinary
already-
Department who has produced a copy of the communication dated 7/6/2023 to submit that.
Respondent number 5, I'm not concerned for it, so my prayer is to confirm that drop it.
Acha. No, what is the letter you want to show? You wanted to show some communication? Has produced the communication dated 16/10/2023 to submit that the department has already sanctioned the amount to be paid to the petitioner as provisional pension and subsistence allowance.
Expenses and
Uh,
GPF also, my lord.
Huh?
And GPF also, my lord. I
As
have
well as the GPF.
GPF also, my lord.
And therefore, the order of this court has been substantively complied with. However, Mr. Borua, learned counsel for the petitioner, submits that his client has not yet received any amount. Since the direction of the court by the order dated 13/3/2023 was to forthwith release the provisional pension to the petitioner, it cannot be said that the order of this court has been complied with. If that be so, it is apparent that there is contempt of court on behalf of the respondents. First up, be that as it may, on the request of Ms. Kotoki, this matter is directed to be listed again on 1/12/2023, so as to give her one more opportunity to seek instruction and appraise this court as to whether the amount has been released in the meantime or not. Mr. B. Dowry, learned counsel, is present on behalf of
Respondent number 5.
number 5 and Mr. R. K. Talukdar.
That's number 3, my lord.
Serially visible.
Apply, deeply applied.
Respondent number 5, can you please strike document? There not been no concern party here.
We'll close it next day.
Right, deeply applied.
Obliged, lord.
Yes. Yes.
May it please your lordship.
How many more?
Lordship, I have entered appearance.
We'll try to finish off.
Yes, I have entered appearance. We have the respondent number 1, your lordship. I seek some time to place the instruction, your lordship. Yes, lordship.
The learned counsel for the respondent number 1, Mr. A. Das, A.K. Das.
A. Das, your lordship.
A. Das pays for and is granted 2 weeks further time to obtain instruction. The learned counsel for the petitioner as well as Ms.
Yes, Leo, for respondent number 2.
For respondent number 2 are present.
Lordship.
Item 45.
I appear for the sole respondent, your lordship. These are same judgment under challenge.
45 and 46.
44, 45 and 46.
So same
order, your lordship.
Same order in
In 45, there is.
45 is the sole
number
respondent.
2. Sole respondent.
In item number 45, there is sole respondent.
45, you write sole respondent.
In 46,
others-
lordship, I appear for the respondent number 1.
I am
So 44 and 46, you are for respondent number 1, she is for
Yes,
respondent.
your lordship.
And in 45, sole respondent.
Sole respondent.
Item 47.
Oblige, your lordship. Much obliged, your lordship.
Arrear salary is sanctioned, lordship. Arrear salary has been sanctioned, lordship.
Alert, I have to take instruction from the client and regarding the GIS, it is the
GIS is being processed, lordship.
business process. So date may given matter.
All right, Miss
R. Bora,
R.
lordship.
Borola.
For respondent number 1.
Borola counsel for the respondent number 1 submits by producing a copy of the communication dated 15/9/2023 that the what has been sanctioned?
The arrear salary, lordship.
The arrear salary to be paid to the petitioner has already been sanctioned, but the
GIS pending.
GIS is initiated. The process has been initiated.
GI.
GIS, lordship.
GIS.
Group Insurance scheme.
amount is currently under process. As such, 3 weeks further time has been sought. Mr. Purkaistola, counsel for the petitioner, also seeks 3 weeks time to obtain updated instruction from his client. Prayer allowed, let the matter be listed accordingly.
Obliged.
Can be linked for others, item 50.
Happy to lordship. Well, in this case, my lord, authorities are directed, so for services concerned for the private respondent, they have filed affidavit, service is complete. Now, my only humble submission, my lord, there is some urgency, my lord, can it be on 2nd week of January, December, my lord, for admission?
Heard Mr. P.K. Decker and counsel for the petitioner also heard Mr.
Lordship, B. Gogoi's name will be recorded.
B. Gogoi, learned counsel appearing for the
Respondents 1, 2, 3, and 4, Health Department.
respondents 1, 2, 3, and 4. Peruse the Lojima Court order dated 24/8/2023, which goes to show that service of notice is complete on respondent number 5, 6, and 7 as well. As such, this matter is ready as regards service on the request of Mr. Deka, registry to verify and list this case for admission hearing in the 2nd week of December.
One more headline, my lord. Authority may be directed, if they wish, then let them file affidavit in this case, my lord.
In the meantime, the respondents may file affidavit if so.
Deep long, that's
May I please the lordship, non-compliance of the order dated 1/12/2022, lordship.
Mr. P.K. Gogoi and Notice 8 weeks, non-compliance of order, willful violation of the order dated.